we apologize for starting 9 minutes behind schedule. We have had a few technical issues on this side, but all of those issues have now been resolved. We're going to start off with a brief welcome address from our chairperson, Mrs. Abimbola Akeredolu, Senior Advocate of Nigeria, and then we'll proceed straight into the first session. Our chairman, Mr. Akeredolu, can we please just hear from you?
Good evening, everyone. Good evening, everyone, and thank you for joining us on this webinar. I will not, there's not enough time to say all the things I'd love to say, but I will just leave the Femina and our panelists to continue our expose on the Arbitration and Mediation Act 2023. What's new, what's next is all up in the air, but Femina and the panelists will help us anchor it down and give us a sneak preview of what the future holds. Thank you very much, everyone, for joining. And I hope you enjoy your time with us. Thank you very much. Femina, thank you.
Thank you so much, Madam Chair. We're going to move straight to the first session. We've done a bit of a move around. We're supposed to have a first session where we talk through the journey to the Act, but we're now going to have a first session where we discuss the reputation of the Act, rather the Act and its impact on the reputation of Nigeria as a seat and the administration of justice, meaning the third session will now become the first session, and the first session becomes the third session. So on that note, I'd like to invite our esteemed panelists, Mr. Babatunde Fagbonlu, SAN, partner at Aluko and Ibadi, Mrs. Folashade Ali, partner at Folashade Ali and Associates, and Mobo Nuvi Majamite. I'm not sure if Mobo is here just yet. He was having difficulties, but if he can't join, I'm happy to move the session forward. So welcome, Mrs. Ali, and welcome, Mr. Fagbonlu.
Thank you.
Hello, everyone.
All right, so without taking too much, we're going to go straight into it. I'm sure everyone is buzzing with news about the Act, just having a new Act around. I remember it was the 26th of May. It was the last working day, if I remember, of the former president when the Act was signed, and there was, panic in place. Has it actually been signed? What has actually happened? What does it look like? But we're finally here. And just in this session, like I said earlier, we're going to look at what the Act has done for Nigeria's reputation as an arbitration hub, and just generally how, the administration of justice ties into what that has done. And in terms of timing, this session is going to last about 40 minutes in total, 45 minutes in total. We're going to talk for about 35 minutes, and we're going to have a few minutes for questions and answers. So just to start off the session, I'd like to just direct the first question to Mrs. Ali. It's a very broad question, but we'll appreciate your expert's perspective on this. And it really is for you to tell us your perspective on how arbitration users, both locally and internationally, see Nigeria as a seat of arbitration and how they view the administration of justice in Nigeria generally.
Thank you very much, Femina, and good afternoon, distinguished ladies and gentlemen. It's indeed a privilege to be invited by LASIAC to give my perspective on how arbitration users, both locally and internationally, see Nigeria as a favorable seat for the conduct of arbitration, and also to look at the issue of administration of justice. First of all, I believe that the topic is extremely timely in view of the recent enactment of the Arbitration and Mediation Act, as we just heard was passed on the 26th of May. So, and this act, obviously, we're also excited about it. And my task is quite simple. It's to briefly look at where Nigeria was prior to the enactment of the Arbitration and Mediation Act 2023. As we all know, arbitration in Nigeria is primarily governed by the Arbitration and Conciliation Act, or it was rather governed which is a federal legislation enacted in 1988 and obviously has been amended. And Nigeria also ratified the New York Convention on Recognition and Enforcement of Arbitral Awards. And this was domesticated in the Arbitration and Conciliation Act. Arbitration, as we all know, the relevance of it cannot be overemphasized, as obviously instills a lot of confidence in foreign investors that want to invest in our economy. But the question is, what really do investors look at, when they're looking for the country to invest in? Is one, they look for a dispute settlement mechanism that allows for disputes to be settled effectively and speedily in an efficient and impartial manner. So the question therefore is today, what factors do parties consider in choosing a seat? The survey, I'll start with statistics. The 2018 survey, the international survey that was conducted by Queen Mary University of London and the law firm of White and Case, gave some factors that we all know, and there are 5 factors. One is the general reputation and recognition of that seat. Users' perspective of the formal legal structure. Namely, is it neutral? Is the legal system impartial? So that perception is key. The national arbitration law, the track record in enforcing agreements to arbitrate, or track records in enforcing the awards itself. And lastly, they look at the quality of the arbitrators who are familiar with that seat. So how do we fare in Nigeria? If these are the factors. The general reputation and recognition of Nigeria as a seat, for me, I think when I want to start discussing this, I first of all look at, we all know that in recent times, or in the last few years, if not more, we've had negative press reports on issues that border on corruption, bribery, and obviously we also have issues bordering on insecurity. But if I want to be honest, I'm not sure security is one of the reasons why Nigeria is not chosen as a seat. And the reason I say this is the same investors that complain that Nigeria is insecure all come to invest in our country, despite that insecurity concerns. So why is it that when it now comes to choosing Nigeria as a seat, they have concerns with insecurity? So I think what then is the problem? One, in my perspective, Nigeria is ranked. If you look at the Transparency International list on corruption, Nigeria is ranked 150 out of 180 countries on that list. I looked also at the World Justice Rule of Law Index, and out of 140 countries, Nigeria ranked 97 when it comes to civil justice, and absence of corruption, we ranked 120 out of 140. So it's clear to all of us that the general reputation on the international plane when it comes to Nigeria is not great. This, in my view, is one of the reasons why Nigeria is not a popular seat that investors look at when considering their choice of seat for arbitrators. Lagos is the economic hub, and as far as I'm concerned, it's extremely safe. So insecurity is out. The second thing they look at is the user's perception. One, are we neutral? As we all know, arbitration and the judiciary will work hand in hand. There's no way, as an arbitrator or a panel, we not need the support of the courts. When we look at when we want to grant injunctions, appointments of our arbitrators in the event where the parties are unable to agree or warn, or where we want to enforce awards, we definitely need the support of our court system. Unfortunately, in Nigeria, the judiciary is perceived, rightly or wrongly, as corrupt. And this has been one of the problems we have had. The neutrality and impartiality of our legal system, therefore, is one of the problems that I think we have. And also statistics still show, when you look at, and I did a quick research, United Kingdom is ranked 15, Singapore 17, but Nigeria were ranked in this one as when it comes to if we're neutral. So the Nigeria legal system obviously has a bad reputation, and the matter has not been helped by bad and frequent press And you know that what comes to light is even recently, we all know about the Senator Bukachua. Rightly or wrongly, that's not the issue. The issue is that when somebody of that caliber boasts that his wife, a former president of the Court of Appeal, that he influenced her in giving judgments, such remarks, in my opinion, is not acceptable, because you know it continues to portray us to foreigners, and they lose confidence in our court system. So the perception of Nigeria, and especially the judiciary, is one of the reasons why I think, you know, Nigeria is generally not chosen as a seat, because there's a perception that the judges are not neutral. Now, arbitration law is another factor, but the Nigerian arbitration law, as we all know, as I've told you earlier on, it was modeled on the UNCITRAL rule. And our previous act, even though it was modeled on it, it was not all sections. And my quick check showed me that 22 of those sections were verbatim reproduction of the model law. 16 originates from the model law, but unfortunately we have 10 that has nothing to do with it. And an example of it is this inclusion of misconduct as a grounds for setting aside. And this has created problems for us, where section 30 of it says that where an arbitrator has misconducted himself, or where the arbitral proceedings is improperly procured, the court may, on application of a party, set aside. Unfortunately, this has led to unforeseen problems, and has allowed the courts to use their discretion to consider things like error on the face of the award as misconduct, and this has led to protracted, delays in awards being final and binding. Also, another point that I think we need to look at is, let me first of all backtrack and talk about the Supreme Court. They've addressed this point and expressly stated that a challenge application is not a merits appeal. And they rejected recently in the case of Nitel and Okeke that the appellant's approach in trying to attack the substance of the award is not acceptable. So we do have the judges who are trying to be proactive, but the general view before this new act is that there's been some problems on this issue of setting aside, which has opened floodgates of cases. Also, the absence of a review mechanism for challenge of arbitrators in the old act. Our section 16 did not have such, and this opened the question of whether courts have the authorities to review the decisions of a tribunal challenging an appointment. Also, there's absence of review mechanism for decisions on jurisdiction. Our section 12 before omitted the article 16.3 of the model law, which allowed parties to seek review of a decision on jurisdiction as made as a preliminary question. And that's allowed that decision to not be subject to review. And this has created, the fear on a lot of our parties, where claimants are reluctant, to bifurcate. And in such cases, because there's no review mechanism, they rather just hold on challenging and wait until the end. And this obviously has also led to some delay. But luckily, I guess Mr. Fagbolu will be telling us about some improvements that they made to our law in the new Arbitration and Mediation Act. Unfortunately, our track record in enforcing also and the judicial attitude has really been a problem. Initially, our judges were very reluctant to enforce arbitration agreements. And it seemed that they considered it as trespassing on their authority. As such, despite the fact that the Arbitration and Conciliation Act provided for settlement of disputes through arbitration, some judges were fond of dismissing arbitration agreements on technical grounds. And we have so many numerous cases, in Mekwede and Mekwen, where, just on technical grounds, because the name was wrongly spelled, Chartered Institute, they held that the clause was unenforceable. However, I believe that with the trainings that institutes like the Chartered Institute, LASIAC, ICC has embarked on, some of our judges have changed their attitudes and they're more arbitration friendly. But we still have a lot of these judges who unfortunately still need training. And this has affected also the perception and the reason why Nigeria is not chosen as a seat. Quality of arbitrators also, who are familiar with the seat, is one of also the reasons. For me, I do not think that's an issue. I believe that we have competent, qualified arbitrators, and I believe that the institutes continue to have training. So in terms of the quality and the pool of arbitrators, I don't think we fall into it. However, as we all know, because of the restriction on the type of who is a legal practitioner, we've had problems in the past because our old section, Article 4 of the rules, restricted and they conferred discretion on the parties that could be retained in arbitral proceedings. I understand I only have 3 minutes left. Wow, I haven't done much. Sorry about, have to rush. So basically, I mean, there was restriction on it, so foreign counsels couldn't come to Nigeria to practice. But now we have to briefly talk about administration of justice. What do we think is one of the reasons why we have problems with the growth of international arbitration? Obviously, domestic is thriving. So why do we think that Nigeria generally is not favored? And I think it's really to do with, if you look at enforcement, before that, the new old acts, there were 4 routes in which you can enforce, and that could cause delay. You could go through the common law route, you could go through the ICSID, where the ACA, all this for me were just not clear, and at times there's unnecessary delay in enforcement. Inordinate delay by the court is also one of the main reasons why we've had problems, because we have cases that go on appeal, and when it goes on appeal, our court system unfortunately have not been that fast in because of technicalities that some of our lawyers put into it. Unrestricted appeals also, because you can continue to appeal from High Court, Court of Appeal to Supreme Court, and there are times where it takes over 11 years to get, to reap the fruit of your award. And this, for me, has been one of the reasons why we have had, why Nigeria is not really favored by investors or parties when they want to choose. So we need to all look at all these points. In conclusion, since I don't have much time, I'll just quickly conclude. Nigeria's reputation as a favorable seat for arbitration and administration of justice obviously faces a lot of challenges. Our reputation on the international stage is not great. And the legal system, unfortunately, has been perceived to lack neutrality and impartiality. Arbitration law had some problems and is long overdue, or was long overdue for review, but luckily we have a review. And the track record, unfortunately, in enforcing agreements has not been consistent. And the delays experienced in the court system has been part of the problems why we've had problems. So we need to enhance Nigeria's reputation as a favorable seat. And I believe that by the time we hear from my learned colleague, Tunde Fagbonlu, we'll see what strides is being made by arbitration community with the enactment of the new Arbitration and Mediation Act. Thank you.
Good afternoon, learned colleagues. If the host could please permit me to turn on my video. My name is Imobonuvie Majimite, and I guess I'm a victim of technology today, because I've been struggling for several minutes, but I just had some issues. I was finally able to get in. Well, yes. Thank everyone for joining. And I had been following, albeit through another colleague's device, so I was able to hear. Yes, I'm waiting for the host to permit me to turn on my video.
Okay.
So that I can. Okay. Yes, I think it's coming on now. Yes. Thank you. Okay, so good afternoon again, Leonard Silk, colleagues and seniors here present. My name is Imobo Nuvie Majemite. I'm actually the host or anchor for this session, but like I had mentioned, I was a victim of some severe technology challenges. So I sincerely apologize for my late attendance to this session, even though I've been following on another device. I thank you very much, Mrs. Ali, for giving us that background as to how Nigeria is being perceived as it sits, and for all the different reasons, particularly from the aspect of the administration of justice. And I'll now please call Leonard Silk, Mr. Fagba, Senior Advocate of Nigeria, to now speak to some of the solutions and under the well-celebrated Arbitration and Mediation Act, what those solutions are and what his views are about them, if they actually address all the issues that Mrs. Ali has identified. Thank you very much.
Thanks, Majemite, and hello again to everyone. Thanks to the hosts, LASIAC, for having me over to talk about the new Arbitration and Mediation Act. Listening to Mrs. Ali, she's painted a very interesting and indeed, I would say, accurate picture of what the issues are. I'd categorize the things she said into three broad categories. I'd say she's identified political issues, political problems. She talked about security. She talked about institutional issues, the quality of the judiciary, which obviously is meant to provide legal support at a seat. So that an ideal seat is one whose judiciary provides ideal support and does not intrude in the arbitral process beyond what is necessary. And then she talked about the legal framework, which is the law itself. So obviously the new act addresses legal framework, which is one of the things that Ms. Ali identified. The new act tries to identify, well, to strengthen procedure so that to some extent might touch upon institutional problems, but certainly doesn't completely do so. It certainly says it does nothing about security. But like Mr. Ali, I'll be very, very, very quick myself to dismiss perceptions about the security situation in Nigeria being a reason why being a challenge to Nigeria being an ideal seat. I liked Ms. Ali's analogy, her reference to the fact that we've got lots of investors here doing business. And so it's difficult to understand how, Nigeria is insecure if there are lots of investors on the ground who are actually doing business. So I'll very readily dismiss that myself. Let's turn to the legal framework. So what Ms. Ali has identified the challenges. Let me start with the point Ms. Ali made about the ease with which arbitration agreements are flouted. As a practitioner, I've not once or twice, not once, not twice, had to deal with, this kind of scenario, which I'm going to paint now. A very powerful Nigerian oligarch has entered into a contract that says that he or she must arbitrate any dispute in London under the rules of the ICC. A dispute arises. And the first thing this oligarch does is to go to the Nigerian courts, having more confidence in a system that he or she probably perceives as one that they can easily manipulate, and not wanting anything to do with a system that they have no control over. I've had this problem not once, not twice. It's a constantly recurring phenomenon. Now, you would notice in my anecdote that Nigeria is not the seat in that example. Indeed, London is the seat, and the institutional choice is the ICC. But that has not stopped Nigerian courts from either taking jurisdiction or purporting to give injunctions to restrain arbitrations taking place abroad. So the problem is not a seat problem. I think it's more of, it probably impacts investors' perception. So if the courts of a country are inclined to disregard agreements to arbitrate wherever those agreements have chosen as a seat, then it's something that's very likely, and Mrs. Ali did mention investor perception when she introduced her remarks. So it's a point that touches upon investor perception, without a doubt. And so it's one that must be addressed. And I think the new law definitely looks to do that by now, for the first time, making it very clear that if there's an arbitration agreement, the courts are bound to stay proceedings, and there are only just a very limited category of exceptions. It's precisely those same exceptions that are recognized by the New York Convention, where the agreement is null, void, or inoperable. It's only in those circumstances that the arbitration agreement will not be implemented by the court. Let's just go back to a bit more detail about what used to prevail under the 1988 legislation. Under the 1988 legislation, you had this very confusing situation in which you had a provision that was based on the UNCITRAL model law and the New York Convention, in the sense that it provided that the courts shall stay proceedings unless the arbitration agreement is null, void, or inoperable. Then you had, following immediately after Section 4, Section 5 that said the courts may stay proceedings if there's an arbitration agreement. And then, in addition to giving the courts discretion to stay proceedings, then proceeded to indicate that, for instance, a judge might be justified in not enforcing the arbitration agreement if the judge perceives that the defendant who applies for a stay is not ready or willing to do anything that's necessary for the proper conduct of the arbitration. And Nigerian courts have pretty much fumbled around what this exactly means. That provision has generated quite some contradictory decisions. You've got some decisions saying that the defendant who seeks to enforce the arbitration agreement is compelled, is bound to start arbitration. You've got others saying that the defendant is not bound to start arbitration. What the defendant should do is to use some language in their affidavit stating that they are willing and able to do whatever is required for the good conduct of the arbitration. Anyway, there's been contradictory decisions over this subject, and a number of arbitration agreements have not been enforced, depending on what the judge perceives the provision to be saying. Thankfully, the new legislation does away with all of that. There is no longer a provision that places the enforcement of an arbitration agreement on a discretionary footing. All arbitration agreements now, whether domestic or international, fall under a statutory regime that says that the court shall stay proceedings unless the arbitration agreement is null, void, or inoperable. And I think that with such a very narrow list of exceptions to enforcing the arbitration agreement, we should begin to see fewer instances in which courts do not enforce arbitration agreements, or indeed fewer instances in which courts grant injunctions to restrain arbitrations taking place abroad. Now, obviously, there are the institutional issues that Mrs. Ali referred to, the quality of the judicial system, the integrity of the judicial system. I will come to deal with those in a short while. Let me take another point that Mr. Ali referred to, and that's the kind of scope of review. So you've done an arbitration, you've got an award. How much, to what extent can a court review the decision of the arbitrators. Now, that is a typical problem that impacts people's minds when they are deciding where to choose as a seat. The standards have been set by UNCITRAL in the UNCITRAL model law as well as in the New York Convention, and the standards are very clear. You can categorize all those limited instances in which courts are allowed to set aside an arbitral award or refuse recognition and enforcement. You can categorize them into three. They are jurisdictional, capacity, and due process. Now, if your complaint against the award or the arbitral process does not fall into any one of those categories, then you must accept your arbitrators as you find them. You cannot review the merits of the award. Now, unfortunately, under the old law, we had provisions that allowed judges to set aside an arbitral award on the basis that the arbitrators committed misconduct. And probably even more unfortunately, Nigerian courts had interpreted the word misconduct in a way that pretty much equated review of arbitral proceedings to something closely approximated to merits review. In particular, you had, so first of all, you had a very long laundry list of the types of situations that would be called misconduct. And of particular concern on this laundry list on this very long laundry list was that ground that says that you can review an award for error of law on the face of the award, which itself ought to be construed narrowly, but many judges, as a matter of practice, tended to construe it broadly. But then even of more concern was the one that says that you can review an award on the basis that there was a mistake of fact. And I'm sure it will be obvious to everyone that when you say a judge can review an award on grounds of mistake of fact, then what it means essentially is that the judge can look into the findings of fact of the arbitrators. Parties can definitely be encouraged, and very often were encouraged, to challenge arbitrators' awards on the basis that there had been a mistake of fact, simply because the arbitrators made a finding of fact that they considered to be against their interests. So what has the new act done? The new act has limited the grounds of review to precisely those grounds that are contained in the New York Convention, those grounds that are articulated just now as being grounds that you would categorize as due process, jurisdiction, and capacity. So if your grounds do not fall under any of those three considerations, then you have no basis for seeking to set an award aside. A related point is a related point in the new legislation is the way in which it has fast-tracked arbitration-related litigation. Before now, we did not have specialist rules of procedure for arbitration cases when they got into court. The new legislation creates a specialist set of rules of procedure. They are contained in the third schedule to the legislation and essentially envisage that you will spend no more than, 3 to 4 months in the court of first instance. You would spend no more than 9 months in an appellate court, and whether it's the Court of Appeal or it's the Supreme Court, no more than 9 months in each one of those courts. And so you have an overall litigation time of about 2.5 years contemplated by this new legislation. And it doesn't only just set those targets, it actually creates practical tools for being able to achieve that. Like, for instance, dispensing with the need for an oral hearing once you filed your briefs of argument, dispensing with the need for you to rely on the registry to compile records of appeal for you. You can compile them yourself. You can compile records of appeal and file them together with your notice of appeal. So in actual fact, you no longer need to wait for 60 days for the registry to compile records of appeal. You can, if you are able to, you can send in your records of appeal along with your of appeal. So it's not just an ambition. It's a project, and the tools to achieve the goals of that project are provided in the legislation itself. Then you've got what you call, I talked just now about the limits on review, and I talked about the 8 or 9 grounds under Article 5 of the New York Convention that the legislation now limits judicial review to. Now it gets even better than that. Those 8 or 9 grounds can be further narrowed down to just 2 grounds if you decide to do what the new legislation describes as an award review by another arbitral tribunal. That's what we call the ART, the Award Review Tribunal. Now, what the Award Review Tribunal essentially means is that from the point you get an award, at the point that you are drafting your arbitration agreement, you can agree with your counterparty that instead of challenging an award directly in court, the award will be sent to an award review tribunal, which itself is a panel of arbitrator or arbitrators. Now, it is not an appeal. I think that one common impression I've heard expressed is that the ART is an appeal. It's not an appeal. It is a very limited review. So the award review tribunal is not re-examining the facts or the law. What the award review tribunal is doing is reviewing the award on New York Convention grounds. Those same points that are described as jurisdiction, capacity, and due process. Now, what that means, therefore, is that the award review tribunal is able to complete its work in a very short time, and the process can be extremely cost efficient and cost effective because it's a process which the law itself recognizes as one that can and should be completed within 60 days from when the award review tribunal is empaneled. Obviously, arbitral institutions that operate in Nigeria will now basically have to enact rules of procedure if they are going to be administering award reviews. They will have to, come up with award review rules. LASIAC is doing that already, and is going to be publishing that for the benefit of the public very soon. And I think the public will see from reading these award review rules how both time and cost efficiency are provided for. Let me round up with one critical point, which Mrs. Ali made, and that is legal services. Yes, one thing that determines whether people will consider your seat attractive or not is the extent to which they can have quality arbitrators in that seat and quality legal representation in that seat. Talking about quality arbitrators, there is no law in Nigeria that precludes an arbitrator on grounds of nationality. So as far as arbitrators are concerned, Nigeria ticks the box. I've appeared before a number of panels in Nigeria that consisted of people from America, from Asia, from Europe. And so there's no problem with getting your arbitrators to sit in Nigeria, unless, of course, they are apprehensive about security, which both Mrs. Ali and I agree, it's not a problem for Nigeria as far as arbitration seats are concerned. The controversial issue before now has been legal representation. Under the old legislation, there was a provision, Mrs. Ali referred to it, Article 4 of the first schedule, that required that you must be represented by a legal practitioner. The L was capitalized, the P was capitalized, and the Interpretation Act therefore directs you to the Legal Practitioners Act for the definition of legal practitioner. We all know what that definition is. Somebody called to the bar in Nigeria. Now, an arbitral tribunal on that basis has held that, or rather had held, that an international law firm could not represent parties in Nigerian seated arbitrations. And of course, one can very easily understand how this will be a disincentive to choosing Nigeria as a seat, because the freedom of choice of legal representation is automatically removed. The new legislation, dispenses without constraints. The phrase legal practitioner has been removed and replaced by what you find in the UNCITRAL rules of procedure, which is person. And I think the signaling that involves is that you don't need to be a Nigerian legal practitioner before you can represent parties in proceedings in Nigeria. So again, the new legislation looks to remove an important constraint that obviously could be a disincentive, and that is the freedom to use legal services of your choice when you are doing an arbitration seated in Nigeria. I don't know how much time I have. I don't know whether I even have any time left, but I will pause there for now, Majemite, in terms of highlighting the ways in which the new legislation seeks to remove some of the legal constraints that previously existed and acted as a disincentive to choosing Nigeria as a seat.
Thank you very much, Mr. Fagbonu, Senior Advocate of Nigeria. Thank you for your perspectives. I'll then ask Mrs. Ali in no more than 4 minutes to please sort of like look into a crystal ball and see how these solutions that Mr. Fagbonu has identified in the Act as having to address the problems that you had earlier identified, to see how we can now move on from theory or move on from paper to reality. What are these pragmatic measures that the Nigerian arbitration community, or perhaps the African arbitration community, needs to do in real terms to make us enjoy the benefits of the Act?
Thank you very much. Thank you, Majemite. As stated by Mr. Fagbonu earlier on, obviously the new provisions in the arbitration and mediation are quite radical and would definitely, if it can be implemented, boost the country to be seen as an arbitration-friendly state. But what do we need to do to translate paper to reality? One, I think it's necessary that there's continuous training of our lawyers and judges. Most of our lawyers still need to be trained and on the innovations of this new act and the implications on the practice of arbitration. There's a need for the courts, obviously, to also know that less interference is necessary. It's a training that I think is necessary. If judges are aware that and the lawyers also are more informed, so advocacy is key, in my opinion. Next thing is, I would suggest that fast-track hearing of matters relating to enforcement and challenge. If enforcement has been told earlier on, obviously it's quite difficult because of the congestion in the courts. But if there's a need to establish a fast-track procedure, which we already have, Lagos State already has one, if other states can do the same, and try and clear also the backlog that we had before. So like the backlog elimination program that LCA and the Lagos State embarked upon when we tried to clear the backlog, if that can be done, that could also assist in ensuring that there's no more backlog and arbitration can be heard, appeals can be heard speedily, even though we already have provisions now that has limited the time. At least now we don't have 11 years. We know that give or take in 2.5 years, we can conclude an arbitration, but who wants to wait for 2.5 years if it can be done earlier? And also on restricted appeals against orders enforcing arbitral awards, I think that would also help if this can, you all have a right of appeal, but if we can follow through on the timelines that be sent. So our lawyers need to be trained. And I give an example. If we look at the Singapore story, what have they done? We need maximum judicial support. And that support can only be if our judges are trained. So recently I was involved in an arbitration where we had been appointed with an international arbitration. For one of the counsel, even though the seat and the place of arbitration rather was in Lagos, went all the way to Owerri to try and get an injunction, stopping us from proceeding with that arbitration. The tribunal continued until we actually got an order from the court stopping us from continuing with the proceedings until the court gave its ruling. I mean, what do we do in such a case? It's clear that some of our lawyers don't even know that we bring in so many frivolous applications, delaying hearings. So we need to honestly try and think of what do we do to such lawyers when they do this? Is there a way we can blacklist them? Is there a way they could be reported, for misconduct? I believe that, the effort needs to be made. And it really it's about training. We need to give the impression that we are more than capable of adhering to the rules that we have set. All that has been said is on paper, but I think that the institutes have a lot of role to play. Chartered Institute, LASIAC, we all have a role to play in ensuring that all lawyers are aware of these new provisions and that efforts are made to ensure that those that do not adhere to them get reported for misconduct as they do in other clients. Thank you.
Thank you very much, Mrs. Ali. Thank you so much for your suggestions. I now turn to Mr. Fagbondu. I find myself having to always restrain myself from calling you Prof, because I think that you are deserving of it. But yes, Mr. Fagbondu, please, we can hear from you now, sir.
Well, I have a prof with inverted commas. Very well. Now, let me start by saying, what's the ideal anyway? The ideal needs to be realistic. It has to be pragmatic, right? So I heard so many people talk about seats, the desire for Nigeria to be an attractive seat. But I always ask myself the question, when people say that, do they really know what they mean? I've heard so many people say that when the real desire is, look, let Africans have more appointments, and Africans will have more appointments if their countries are seen as an ideal seat. I don't think that's correct. Like I said earlier, the fact that your country is an ideal seat does not mean that the nationals of that country will get more appointments. It only means that more arbitrations will happen in that seat, but arbitrators can come from anywhere in the world. So we need to understand what we mean when we say seat. It's actually it's a much more nationalistic objective than many people realize. It is economic. In actual fact, the motivations are mostly economic, right? And when I say mostly economic, what it really means is that you want to diversify what you earn income from as a country. You no longer want to be a banana republic, one in which the only thing you sell to the world are natural resources and raw materials. You actually want to export services. And because you want to do so, you've identified legal services, particularly arbitration, as one of the services that you can export, right? Now, that is what is meant when you say you want to be a seat. It's a nationalistic and an economic objective. That's how people should see it. And the question is, what's realistic? What can we achieve? What are our low-hanging fruits? I think our low-hanging fruits is, number one, to be a seat for Africa, okay? We want to attract arbitrations between, involving disputes between players and governments, private sector and governments from countries other than Nigeria. We want a South African contractor who's done a project in Egypt to agree with the Egyptian government to use Lagos or Abuja as a seat. That's the objective. Where are we in terms of being able to achieve that? Currently, nowhere at all. Not with the kind of judicial system we have, not with the kind of legal system we have. And so that is the goal, that's the target. I don't think that, a good number of the multinationals that do business in Nigeria, if the bargaining strength lies with them in terms of choosing a seat, they will naturally gravitate towards Paris or London or New York or Geneva. It's going to take a long time to be able to displace those seats where multinationals are concerned, where non-African multinationals are concerned. But when it comes to African players, we can aspire to that, but there's a lot that we need to do to be able to aspire to that. I think we have a good start here in the sense of we have a good legislation that is even more compliant with UNCITRAL standards, and that is good. We now need to put the institutions in place, strong institutions. We've got to examine the factors that we consider when we appoint judges. We have to examine the efficacy of our rules and institutions for ensuring ethics in the legal practice itself. We have to examine our legal education system. To what extent is it contemporary? To what extent is it imparting contemporary and relevant knowledge to young lawyers, young practitioners, right? So these are the things that we have to do in addition to having good laws to be able to achieve the ideal of having Nigeria as a hub for intra-African transactions. And with the Africa Continental Free Trade Agreement, taking on steam and becoming, the framework for achieving greater markets and business across Africa, it would be a shame if Nigeria couldn't, prepare itself for the opportunities that this kind of regime presents. Thank you very much.
Thank you very much. I think there's a reason why we could go, Prof. Thank you very much for your thing. So now I thank all the participants who have written out questions. But from what I'm reading, I can see that some questions are actually better answered by subsequent panel sessions. And I would please ask that, for example, and I hope I pronounce her name correctly, Shireen Toki. I believe your question will be better answered after you've listened to the session on the Award Review Tribunal. So we'll not be taking your question at this point. But there's a direct question here from Leonard Senior Advocate, former Attorney General of the Federation, Chief Bayo Ojo, for Mr. Fagbonlu, SAN. And I will just read out his question. He says, I will appreciate it if Mr. Fagbonlu could please let us know the provision of the old Arbitration Act, which he said allows the judge sitting over a challenged award to look at the facts of the award. Thanks. That's his question. Mr. Fagbonlu, are you able to?
Yes, indeed. I saw that. Yeah, Chief Ojo, thanks so much for the question. I think my answer to that would be it's Section 30 of the old legislation, Section 30 of the Arbitration and Conciliation Act, because it has the ground called misconduct. And in the way that ground has been elaborated in judicial decisions, it's been elaborated to include allowing a judge to entertain a ground that says that the arbitrators made a mistake of fact. Now, obviously, in my view, in examining whether the arbitrators made a mistake of fact, you would have to look into the factual issues involved in the case. So you wouldn't find challenge on grounds of fact in the act itself. It is encapsulated in the word misconduct and in the way judges and courts, including the Supreme Court. I think the locus classicus on this point is the case of Taylor Woodrow and the Tina work. And it's that case in which you see a long laundry list of everything that falls under that single word misconduct. And one of them is the ability to review for mistake of facts.
Thank you very much. Lolade, again, please, we'll take your question with the Award Review Tribunal session. Mr. Shehu Mustafa, would please ask that your question be answered by another panel. Okay, yes. Okay, so we have two more questions, one from an anonymous attendee, and I will let both Mrs. Ali and Mr. Pagbonlu to answer the question in 1 minute each. Says, apart from foreigners who may represent parties in Nigeria, what is your impression of some Nigerian arbitrators who are not lawyers, talking about accountants, engineers, medical practitioners, who are dispute resolution professionals? Mrs. Ali, in 1 minute,
Yeah.
what was your impression? Yes.
I think Sheu's question is quite straightforward. I mean, what he was asking us is, I mean, if you look at the SNEPCO case, basically what happened was because FIRS, who was not a party to the contract, challenged the award on the basis that it was a tax issue and therefore not arbitrable, and the court allowed it. So what he is asking us is that, do we think statutory definition of it in future would, reduce the cost? I believe so. I believe that would make it easier. And I think regarding who can represent, parties can actually represent themselves. The only thing is that if you want to have counsel, you can. If you look at the fact that as an arbitrator, it's not only lawyers that are arbitrators, so long as you're qualified. So if you have a dispute that is not actually, that has to do with accounting, and you decide that you want a medical or something to do with medical negligence, and you want the medical practitioner to, I'm not sure that anything stops you from doing that. What is done, you sync with whoever you choose to represent you. And I think that's just the point. The fact that it's now been open to foreign counsel to represent is arbitration. In my opinion, if you decide that you want to represent yourself or you want somebody else, it's allowed under the Act.
Thank you. Prof, do you have anything to add?
Well, I think Mrs. Ali said it all. The only thing I'll probably add is that the world of dispute resolution outside the courts is becoming increasingly multidisciplinary. And so you've got lawyers learning project management, engineering, design, if they want to be able to represent parties in construction, arbitrations. You've got quantity surveyors, engineers, project managers, learning law and arbitration, if they want to be able to do a lot of dispute avoidance and dispute management effectively. So the world of dispute resolution outside the court system is becoming increasingly multidisciplinary. And, and so I think it's something that we should expect. I think it's only natural that, people from other professions across the different sectors can qualify to be arbitrators. I guess, I think, and indeed, arbitration is a kind of profession in which you don't even need to have any formal qualification. What you need to be an arbitrator is for parties to appoint you. Like Mr. Ali rightly said, you can represent yourself. And so in those days when arbitration started, when you had what you call sniff and look and sniff arbitrations in commodity arbitrations, it wasn't lawyers who are arbitrators, it was commodity traders who knew about the trade.
Okay.
So essentially, I think the reality of this job now is that it's multidisciplinary.
Thank you. So just two final questions. Max Ikombe wanted a clarification. Says, can a foreign lawyer also act in a purely domestic arbitration? I heard Prof speak on that, but didn't quite catch whether there's such a distinction. Prof, do you want to just quickly clarify again for Max?
Yeah, I think at least, in theory, yes. The answer is yes. Because the amendment that's been made to the legislation is not in a provision that relates exclusively to international arbitration. I think, in fact, this new legislation has significantly de-emphasized that former dichotomy between domestic arbitrations and international arbitrations. Obviously, there are still some provisions that are only applicable to international arbitrations, but that specificity has been significantly watered down. With the result, I think that notwithstanding that an arbitration is domestic, a foreign lawyer could represent parties. Bear in mind, of course, that with some of those arbitrations that you call domestic, there are still significant multinational interests involved. So you know your Section 54, well, your Companies Allied Matters Act says that to do business in Nigeria, you must incorporate as a Nigerian company. And you've got companies operating in Nigeria that are almost 100% owned by foreign interests, but they are Nigerian companies. By definition, you would say that a dispute between such a company and one of its Nigerian contractors is a domestic arbitration, but there are significant foreign interests involved. And so the tag that you put on a particular arbitration is never really reflective of the economic realities. And so I think that would be one reason why you certainly wouldn't be able to advance a theory that says that you know, the ability of a foreign lawyer to represent parties in Nigeria is limited only to domestic arbitrations. Sorry, international arbitrations.
Thank you.
Yeah.
International arbitration.
Yeah.
Okay, so there are two more questions. The question from Pontian Okoli. This question is the next session actually about the salient provisions of the Act. So I'll please ask that the asker of the question please keep their gunpowder dry. It will be answered in full when that session is taken. But then I have a final question from an anonymous attendee. I'd ask that questions relating to the award review tribunal also be stepped down, but then this person specifically appreciates if Prof answers the question. So Prof, please, in just 1 minute, because we're actually running for time. The person asks, what was the idea behind the ART? They haven't seen any country with such a development, and they would appreciate your answer to the question. Thank you. Okay,
just to answer very briefly, it was to ensure that, one, you limit the scope for judicial intervention in an award, and thereby also limit the amount of time you spend relitigating matters that have gone through arbitration already. So that, to put it very short and very sweet, is the idea behind the ART. And as to not knowing other countries where it is done, in actual fact, the American Arbitration Association and the International Center for Dispute Resolution have a joint scheme that is even more robust than the one that we have in the ART. When I say robust, I mean that it allows for full merits review by another arbitral panel. The same thing with the Judicial Arbitration and Mediation scheme, JAMS, in the United States. They also have an arbitral appellate process. Then, of course, ICSID has what they call the, I think they call it, you know, they have a review process where you can also review, you know, awards of ICSID arbitral tribunals. So I think there are examples. Annulment proceedings, exactly. Thank you very much. They have annulment proceedings. So there are examples. They are not exactly similar to what we have in the ART. The ART is actually very streamlined and very limited in terms of its scope.
Thank you very, very much. Thank you so much. So I think that we've answered all the questions that pertain to our session. Yes, will a recording of the session be sent to all registered attendees? Well, I'll let the organizers, LASIAC, confirm that. I'll just let the organizers confirm that. I can't speak for them. But in rounding up this session, I want to thank my very distinguished and erudite panelists, Mr. Tunde Fagbonyu, Senior Advocate of Nigeria, Mrs. Folashade Ali, Fellow of the Chartered Institute of Arbitrators, Chartered Arbitrator. Thank you very much for bringing your expertise and your industry to this topic. I would say that we are very optimistic that with the proper and intentional implementation of this act, that Nigeria will be more seen as a favorable seat of arbitration. I think that's the general view. And we can only hope in the coming months, as time goes by, that we begin to reap the benefits of the amount of industry and work that has gone into this act. I also thank the attendees for listening as well with rapt attention. I thank the questions that have come in as well. It shows that people were listening very carefully. And I ask that we also give the same ear to the next panelists who the organizers will introduce. Thank you very much and have a good afternoon.
Thank you so much, Mubu. Thank you, Mr. Fagbonlu SAN. Thank you, Mrs. Folashade Ali. It was a pleasure listening to you. We're going to move straight to the next session, which is actually my session, where we do a surgical look, a surgical analysis of the new act. And on this session with me, I have two very brilliant practitioners, and they have doctorate degrees to go for to show for it. I have Dr. Babatunde Ajibade, Senior Advocate of Nigeria, Fellow of the Chartered Institute of Arbitrators, and I have Dr. Abayomi Okubote. Both of them are my role models, and I think that's something I need to say. I need to get a PhD as soon as possible to match them. But I know it's going to be a great session, and we're just going to go straight into it. We shared the profiles on the LinkedIn page, so please check the LinkedIn page for their full profiles. Nothing I say in 2-3 minutes can do them justice. And on that note, we're going to go straight into it. Between the three of us, we're going to look at the provision of the Act in 3 sections. We're going to look at the most practical changes that the Act has introduced, knowing fully well that we're limited by time and cannot touch on everything. Dr. Abayomi Okubote will look at the general innovations in the Act, the ones that affect the general framework and practice of arbitration. I would thereafter look very quickly at the changes to the Act that affect the process leading up to the award, that's right up to the award. And Dr. Ajibade will come in with his expert perspectives on the changes to the Act from when the award is rendered. So Dr. Okubote, Bayomi, can you please just run us through? Unfortunately, we're short for time, so we need to do this in at least 10 minutes each. It's very challenging, but let's see.
I'll try. Thank you very much, Efemina. I'm delighted to be speaking to everyone today on the Arbitration and Mediation Act, recently signed into law by the President. And I would like to say massive congratulations to the committee members that worked on the Act, and to the Nigerian arbitration community in general. So in this webinar, I'll be covering 3 important features of the AMA. First is the relationship with state legislation and power of courts. I see that someone asked a question on the relationship between the Lagos arbitration law and the new Act, so I will speak on that shortly. I'll also speak on third-party funding in arbitration. And if time permits, I'll just quickly go over mediation. So while it is impossible to cover these features in detail within the limited time that I have, Femina has said I have 10 minutes, I will just quickly try to identify the core issues implicated by the amendment and highlight the legal or practical considerations of the amendment. So starting with the scope and application of the Act, Section 1, Sub 5 of the Act provides that the Act shall apply to international commercial arbitration, subject to any agreement in force between the Federal Republic of Nigeria and any other country or countries, that it shall apply to interstate commercial arbitration within the Federal Republic of Nigeria and commercial arbitration within the Federal Republic of Nigeria. Now, this language in Section 1 Sub 5 is more extensive than the provisions of Section 58 of the Elsewhere Arbitration and Conciliation Act, which simply states that the former Act shall apply throughout the Federation. But the issue thrown up is whether the Act, the Arbitration and Mediation Act, the AMA, has resolved the conflict between federal and state arbitration legislations. Now, I will not dwell too much on the constitutional debate about the legislative competence of state and federal government over arbitration, but suffice to say that in 1988, Nigeria's federal military government promulgated the Arbitration and Conciliation Decree, which then became the Arbitration and Conciliation Act, to provide a unified legal framework for commercial arbitration throughout Nigeria. So at the time that the decree was promulgated, the federal military government had unlimited competence to legislate over any matter in and for all parts of Nigeria. But the question is, under the current, Nigeria's current constitutional democracy and federal structure of government, legislative powers are now shared between the federal government and the state government. So the point to note is that, we have the exclusive legislative list, the residual lists, and the concurrent list. And the view that has been canvassed, which I agree with, is that in light of item 68 of the exclusive legislative list, arbitration is incidental or supplementary to trade and commerce, which has been expressly mentioned in that item, even though arbitration was not expressly mentioned, but is incidental or supplementary to trade and commerce that has been expressly mentioned. So accordingly, the federal legislature has exclusive competence in respect of arbitration concerning international and interstate arbitration, whilst on the flip side, state legislatures will have legislative competence to enact arbitration legislation in respect of purely intrastate arbitration, that is, arbitration with connections solely to the concerned state, as this will be a residual matter which, of course, not being addressed in the Constitution, falls within the legislative competence of the state. And I think this is much clear from the provisions of Section 1 of the AMA. Now, what is more important for me to address on Section 1 is what Ifemina, in the course of our recent debates some days ago, has christened the death of Limak and Sahelian. I don't know if all of us are familiar with that case, but I will try to unpack this so that we all understand the essence of that important debate. Now, Section 1, sub 7 of the AMA provides that the court's powers under the section shall apply where the seat of the arbitration is outside the Federal Republic of Nigeria, or the parties have not designated the seat, or no seat has been determined. It then goes on to provide a list of circumstances where when the court can exercise such power, which can broadly be categorized into three. One, stay of proceedings, interim measures of protection and compelling of witnesses, and then recognition and enforcement of foreign awards. Now, the question thrown up by this subsection is whether, in the first place, it's a closed list, being that Section 1, sub 7, paragraphs A to G has listed those items, and the question is whether it has sufficiently carved out the power of Nigerian court in relation to foreign seated arbitrations. For example, the power to set aside foreign seated award, as was the case in Limak and Sahelian. In that case, the Nigerian court set aside a Swiss seated arbitral award, and rightly so in my view. I know that there has been a stimulating debate on the Court of Appeal decision in Limak's case. I will not take too much time to dwell on that because I would still like to cover that other part. But the real issue for me is the question whether the Nigerian court has power to set aside a foreign seated award. On a general note, I would say yes. I know a lot of people, this is an unpopular opinion, so a lot of people may not agree. And I say so because, and the base of my understanding is that the assertion and the position widely held that Nigerian courts cannot set aside foreign awards, or that awards can only be set aside at the seat of the arbitration, has no cogent basis in law. And I mean, it's at best a relic of the jurisdictional theory, or what Professor Emmanuel Gaillard of blessed memory calls monolocal theory. And these views of the monolocal theory underscores the importance of the seat of the arbitration and emphasizes the fact that an arbitration or international arbitration must take place somewhere and therefore can only exist to the extent that a single national order, meaning the seat of the arbitration, permits it to exist. But beyond the monolocal theory is the multilocal, or what Gaillard called Westphalian representation of international arbitration. And that anchors the arbitral process in a plurality of legal orders and sees the law of the seat, or the seat of the arbitration, as one of the legal orders among others. So with this understanding, or with this in mind, let's then go back to the question whether only the seat of the arbitration can set aside an arbitral award. When I've discussed with a lot of people, when asked for the basis for this position, what the monolocal proponents will point to is Article 5(1)(e) of the New York Convention, which gives an enforcing court the discretion to refuse recognition and enforcement of an arbitral award that has not yet become binding on the parties or has been set aside or suspended by a competent authority at the seat of the arbitration. And I struggle to see why Article 5.1e can conceivably be the basis for the proposition, and I say so for the following reasons. Number one is that I've taken time to read the draft works, which is the historical document containing the negotiations of the drafters of the New York Convention, and I stand to be corrected. I've not seen anywhere where it was agreed that Article 5 relates to annulment of awards. Now, the article, in my understanding, relates strictly to recognition and enforcement of awards, and it then provides grounds when the court can refuse such enforcement and recognition. It does not seek to regulate annulment proceedings, and rightly so, because annulment of proceedings is regulated by national laws in different countries. And the second point is that relying on Article 5.1e is unhelpful, given, as we all understand, the continuous debate and the different approaches between the French court and the English court as it relates to awards, enforcement of awards set aside as a seat. The point being that the French court today ascribed no significance or primacy to the seat of the arbitration and have traditionally enforced awards set aside as a seat, relying solely on the French civil code. And the third point on that is that given the multi-local theory as it relates to annulment of awards, I believe it is the seat of the arbitration and any other jurisdiction having a close connection to the award or the underlying commercial transaction or the enforcement of the award that can set aside that award or annul it. Now, setting aside an award in one jurisdiction, of course, does not necessarily mean it cannot be enforced in other jurisdictions. So the case in Limac, in which the underlying transactions, as I understand it, was in clear breach of the Nigerian law and renders performance of the contractual obligations and compliance with the award a breach of Nigerian public policy, I believe that it's one that could ordinarily have been set aside by the Nigerian court. And I do not think Section 1(7) of the Arbitration and Mediation Act changes anything, given that there's no clear language in that section to render the items as a closed list or otherwise circumscribe the powers of the court to set aside foreign awards in deserving cases. And now quickly on third-party funding, I think those provisions on third-party funding are part of the innovative provisions in the new acts. Now, the legislative response to third-party funding or that funding arrangement is driven by a desire to realize its many benefits. And those benefits include improved access to justice and support for companies seeking to maintain balance sheet solvency and cash flow. Now, with the increasing capital inflows and growing commercial activity, as well as the attendant growth in commercial and investment disputes, I believe Africa is poised to become a massive funding market in the future. So Nigeria and the parliament and the committee should be commended for getting ahead of the curve and putting a permissive regulatory framework in place now. Now, in terms of the drafting of those provisions, a tripod approach was used or utilized in drafting those provisions. The first is the abolition of the traditional provisions of charter and maintenance. Given that those common law provisions continue to be enforced in Nigeria and they have been applied as a framework within which the validity of third-party funding arrangements have been assessed. As recently as 2015, the Nigerian Court of Appeal reaffirmed that the financing of a lawsuit, I think it was Ogaku JCA, that the financing of a lawsuit for a share in the proceeds of the suit is champertus. So what Section 61 of the Act, the AMA, has done is to completely abolish champerty and maintenance. They are no longer applicable to arbitration seated in Nigeria or arbitration-related proceedings before Nigerian courts. Now, the second dimension in terms of the approach is the mandatory disclosure of third-party funding. And the provision on disclosure became important because of the ethical issues that may arise from third-party funding, in particular, conflict of interest created by prior or ongoing relationships between the arbitrators or their law firms and funding institutions. Now, mandatory provisions became important and will be helpful to help arbitrators and arbitral institutions to conduct conflicts check so as to insulate the award in that proceedings from potential annulment based on conflicts. Now, the third dimension is security for costs, which has become a serious concern for many tribunals. Now, the approach that was used or utilized is that disclosure of third-party funding does not automatically justify the grant of security for cost, nor is it an evidence of impecuniosity of the funded party. Now, the tribunal will have to satisfy itself of the merit of the security for cost application, including admitting an affidavit from the funded party or its counsel showing that the funder has committed to cover adverse costs in the case. Now, this approach aligns with the regimes in other jurisdictions like Singapore, Hong Kong, Sierra Leone. Those are the 3 other countries that have introduced a permissive statutory framework on third-party funding. I'm privileged to have worked with the government of Sierra Leone in drafting the recently passed Sierra Leone Arbitration Act, and I'm currently working with the government of Malawi in reviewing the arbitration bill, and the same approach has been taken in those bills. And the implication of that is that with time, we'll soon be seeing consistent statutory provisions on third-party funding across different African countries, which will enable the development of funding market in Africa to attract local foreign investors in that market and make arbitration a more viable option for dispute resolution in Africa. If you do I still have time to quickly watch through mediation?
We'll give you 1 minute.
Yes, and I will utilize it well. So I believe mediation is one of the important additions to the AMA, given the complete removal of conciliation from the Act. The provisions of statutory framework for domestic and international mediation, domestic civil mediation, and enforcement of international settlement agreement arising from mediation proceedings. The Act also domesticates the Singapore Convention. So the provisions of the convention are now applicable in Nigeria to international settlement agreements made in a foreign country, and it states the conditions for the application of the Singapore Convention. So these provisions aim to promote as an alternative and effective method of resolving dispute mediation in Nigeria. Although we know that mediation has been incorporated into the rules of the different courts in Nigeria, but by providing binding procedural mechanisms, it is expected that the AMA will bring more certainty and stability to the practice of mediation and provide what I see as a statutory ballast to enforcement of international settlement agreements arising from mediation proceedings. Did I use the 1 minute?
Perfectly. Thank you so much, Doc. Thank you so much. And just on the back of that, I have to keep the time myself. I'm going to talk very briefly about 3 key changes introduced by the Act in relation to the process from when the arbitration commences down to when the award is rendered. I'm going to start with what I think is a very important one, which is obviously the stay of proceedings, which is now in Section 5 of the AMA. Unfortunately for me, Mr. Fagbonu covered a bit of this. I'm just going to go straight into the issues. If you remember, the old Act had 2 provisions, Section 4 and Section 5. And Section 4 was the more familiar one, the more friendly one, which introduced a binding obligation on courts to stay proceedings commenced in breach of an arbitration agreement when there was an arbitration agreement. But Section 5 made it discretionary. Now, apart from making it discretionary, it also said you could only apply for a stay of proceedings pending arbitration before the filing of the first pleading and before taking any other step in the proceedings, meaning that there was this question of taking a step, which I'm going to go to shortly. There was also the question of willingness. The Act required an applicant to show that it was willing at the time of commencing the proceedings and at the time of applying for the stay to proceed with the arbitration. But all of that is gone under the new Act. And under the new Act, we have a Section 5 of the Arbitration and Mediation Act that mirrors almost exactly what we have under the New York Convention and under the Austria model law. And just to take a brief look at it, I'm going to ask myself 4 questions, and I want you to follow these 4 questions. And these 4 questions essentially go on the first 2 talking points you see on the screen. And it's just simply where you want to file an application, what are the things to consider? What do you now consider under the new Act? And obviously the first thing is, can you go ahead to file this application? Are you precluded from filing this application by any step you have taken? Like I said, in the previous Act, we had the phenomenon of taking a step. Essentially, if you are taking a step in the proceedings, you were precluded from filing an application for stay. And if you did that, you were going to be refused your application for stay was going to be refused. Now, under the old act, we had two broad schools of thought on what taking a step meant in terms of this proceedings, the stay of proceedings application. And this is just what the case law says. And the first school of thought says you are only taking a step when you do something in defense of the action that's been brought against you, and the second school of thought was, you're taking a step when you take any step at all in the proceedings. Now, just to put that in context, the first school of thought says you filed a statement of defense, you've taken a step, or you filed a motion for extension of time for the statement of defense, then you've taken a step. And once you do either of those two things, your stay application will be refused and you have to continue with the litigation. The second school of thought says anything you do at all, an affidavit, a motion for extension of time unrelated to defense will count as taking a step. And this has generated a lot of debate in Nigerian courts over the years. But what we've seen with the new act is that all of that taking a step is gone. What we have now is a question of what is the first statement on the substance of the dispute? Because what the new act does is to say you can file a stay of proceedings application if you have not if you've not filed your first statement on the substance of the dispute. And what do we see this? How would this apply? And even though the old case law is now in the past, we have some guidance on how this is going to be interpreted. Under most model law countries, this is seen as filing the statement of defense itself. That's the pleading, which would be a very pro-arbitration approach. But what the old case law shows us, and I have two of these cases here. I have MV Lupex 2003 Supreme Court decision, and I have Eaglewood, which is a 2017 Court of Appeal decision. It shows that Nigerian courts are in two minds. And the first one goes with the model law prescription, which is that you file your first statement on the substance of the dispute when you file your statement of defense. While the Eaglewood case looks more at substance rather than form and says, if you do file any other process that is a substantive defense to the claim brought against you in the courts, then you will be counted as filing your first statement on the substance of the dispute. And these are the two things to keep in mind going forward. But I think the preferred view by most pro-arbitration practitioners will be that you can go ahead to file a motion for stay of proceedings at any time before filing your statement of defense. But I think these are the two views that we should bear in mind going forward. So the jury is still out. I think the key thing to bear in mind is that the arbitration agreement is in itself an agreement. When a claimant commences the proceedings in breach of the arbitration agreement, you tell the claimant, look, there's an arbitration agreement which you've breached, which you move to arbitration. You are enforcing that breach. The step you are taking in terms of conceptually looking at that amounts to an agreement to litigate, an agreement to revoke the arbitration agreement. So this is something we should bear in mind going forward. Some questions which came to my mind while preparing was, and in Lagos State, for instance, where we have the pre-action protocol proceedings, what happens if both parties threaten each other to sue in pre-action letters and they get before the courts? Obviously, the jury is still out on all these points. Still on the constitutions for you to file, the next thing is, what do you have to demonstrate when you file your application for stay? And the old act, we had willingness. You had to demonstrate through affidavit evidence that you were willing to proceed with the arbitration. Again, we have two broad schools of thought. One school of thought, which is epitomized by the MV Lupex case, Supreme Court 2003, was that you just had to file affidavit evidence saying, I'm ready and willing to proceed. But we have the other school of thought, the problematic school of thought, which is the Panoramas case. And we have the, I think that's UB and Trident case, where the courts expressly said you had to file a document notifying the other party of your intention to commence arbitration and proposing to appoint arbitrators. Thankfully, this new act has gotten rid of all of that, which is quite frankly not very arbitration friendly, and which is counterintuitive when you think about the fact that the party who commences the action at court is actually the party in breach of the arbitration agreement. All you need to show now under the new act is entirely what you need to show in any international jurisdiction, which is that the dispute in question before the court falls within the scope of the arbitration agreement and is covered by the arbitration agreement. Now, having just discussed this, we move to the next point, which is, if you're resisting the application for stay, if you are insisting that the claim you have brought to court has to stay in court, what are the things you need to do? And I've gotten a few phone calls saying, but if the courts are not allowed to look at the invalidity of the arbitration agreement, the inoperability, and the fact that it's incapable of being performed. And this is a very crucial question. I think, when you look at it, it's a question of fact, and it's a question of fact that most courts will resolve through evidence. But what is more concerning and what will concern most practitioners is how far can the courts go, bearing in mind the fact that the tribunal has the competence powers, even under the new law. And I think what we're likely to see in courts is that practitioners are going to be trying to adopt the literal rule to say, it says invalidity, it says incapable of being performed, it says, inoperative. And we're going to take that very literally. But I think the answer is quite simply in section 91, subsection 10. And what that section says is that in interpreting the act, you have to consider its international origin, you have to consider the uniformity in application and good faith, and of course, the travel preparator of the model law. But I think the key thing to focus on is the international origin. And as most people already know, Section 5 of the Act on Stay of Proceedings has its origin in the model law, and the model law has its origin in the New York Convention. And what the New York Convention prescribes through academic papers, through its usage in courts, is that at the stage when the court is approached to determine the stay of proceedings application, what the court needs to do is a prima facie review. The court has an obligation to stay proceedings unless it is manifestly clear to the court that the arbitration agreement, and I emphasize arbitration agreement, not the main contract, is invalid, is inoperable, and incapable of being performed. I have just 2 minutes to go, so I'm going to round this up very quickly and touch on the other 2 points. But the key thing here is, if you look at our legislation, in addition to section 91, subsection 10, you also have the doctrine of competence, which is in section 14, which shows you very clearly that the intention of the drafters of the act cannot be for the court to conduct a full review when deciding a stay of proceedings application, because section 14 says the tribunal has the competence, and when the tribunal decides, within 30 days, you can go before the court. So what courts should do in line with global best practices is to stay proceedings, unless, of course, on the face of the evidence, it is manifestly clear that the arbitration agreement itself and not the main contracts is invalid, inoperable, or incapable of being performed. I think one final point to emphasize in this regard is that we're talking specifically about the arbitration agreement. The section that deals with non-intervention of courts says the court shall not intervene unless allowed to do so by this act. And what section 5 allows the court to intervene to do is determine whether the arbitration agreement in and of itself is invalid. A few cases which will come very handy going forward in our court to be the Fiona Trust case versus Privilove is a UK House of Lords decision, which talks about exactly the same issue. I think the next thing I would say is that section 5, subsection 3 introduces a very interesting provision which will come in handy. It says that in granting a stay of proceedings, that the court is allowed to make orders, interim or supplementary orders, to maintain the rights of parties. And I think one thing that's come to my attention recently is how parties insert arbitration clauses and get stay orders so they can frustrate the case. One thing that is likely to happen now with this provision is that when a court stays proceedings, the courts can make orders as to how parties can commence the arbitration soon enough, and the timeline in which they can do this before, of course, when a party is in breach, coming back to court if necessary. My view aligns completely with Prof. Tunde Fagwondo's view, which is that the party who is in breach of the arbitration agreement by commencing the proceedings has to start the case, of course. And it will be interesting to see what conditions courts lay down to enforce that procedure when they grant stay of proceedings. My other 2 points are very brief. The first one is that obviously under the new act, when the parties don't agree on the number of arbitrators, the number is now 1. This has significant cost implications. You no longer have to pay for 3 arbitrators in your ad hoc proceedings, you now pay for just 1. So hopefully this makes things slightly cheaper. Unfortunately, one of the things that came up in my discussions with Dr. Ajibade before this session was where parties cannot agree on a sole arbitrator or on any arbitrator whatsoever, the Act introduces alternative appointing authorities. So you can either go to the courts or any arbitral institution in Nigeria. Fortunately, court has now been defined as a judge in chamber, so you write a letter to the judge. You no longer have to file a motion. But the question is, what happens if the claimant goes to LASIAC and the respondent goes to the courts, how do we determine, priority? Obviously, it's a very messy situation, but I think what the Act intends and what the Act envisages is that the first to apply and the first to appointment will take precedence, of course, because once an appointment is made, then the power to appoint is dissipated. It's also worth mentioning that in relation to international arbitrations, the Regional Center for International Commercial Arbitration in Lagos is a default appointing authority. My final point, I'm now 1 minute over my time, is just the freedom to choose procedural rules. Under the old Act, for domestic arbitrations, you were forced to choose the arbitration rules in Schedule 1 of the Arbitration and Conciliation Act. Under the new Act, parties are now free to choose whatever rules they please to govern their arbitration, including, of course, the LASIAC rules, which are, of course, very handy. And this would help arbitration institutions choose their offerings, like in the Western world, in London, in Paris, we have ICC, which scrutinizes award for greater quality. The LCI does not do that. The LCI instead appoints all your arbitrators to give you quality arbitrators to ensure a good decision. It's expected that arbitration institutions will now reshape their offerings to match what the new Act has done. I think one more point to say is that this provision is very important because since we have revised the ground for setting aside awards to include non-compliance with procedural agreements with the parties or the procedural rules agreed to by the parties, if this provision was not in place, parties adopting LASIAC rules, for instance, could have their awards set aside on the ground that they did not comply or they did not have their arbitration governed by the rules in the first schedule. So we're basically in line with global best practices and we're in a really good place. That being said, thank you for listening. And Dr. Ajibade, over to you.
Thank you very much, Femina. Good evening, everybody. Let me start first and foremost by joining in applauding those who have spent, I think it's upwards of 10 years in fighting to get this legislation to become reality. Really, we can't thank them enough because they've really put Nigeria on the map now, where arbitration is concerned, or further on the map. Nigeria was always on the map, at least by African standards. But I think our position on that map has been consolidated significantly by this legislation. I think one general point I'd like to make before I go into the surgery that Femina has asked me to do, and I must thank him for preparing these very useful slides. One general comment I'd like to make is that I don't know what the process was that led to the enactment of the 1988 legislation. I haven't looked into it, but some of the complications we've seen in the interpretation of that legislation it was obvious to me that it arose from a significant amount of cutting and pasting, and that some of that cutting and pasting was not done with a view to, with an experience of the challenges that the legislation was expected to address. I think the AMA 2023 is a massive departure from that. Even listening to what has been said so far and listening to Abayomi and Femina's analysis of some of the sections, one can see that the drafters of this legislation were drafting the provisions with a view to addressing problems that had already manifested in our courts, in litigation around the previous legislation, the ACA. And they've done their best to address those problems that had been identified. But again, just to say right off the bat that the fact that you have new legislation and that legislation has or aims to address problems that have been identified does not mean that you're not going to have further disputation going forward. So straight away, I can tell you I don't agree with Abayomi's view in relation to Sahelian. I still think that the power to set aside ought properly to be reserved for the courts of dispute. And I think that at least by inference, this was the discussion I had with the Femina before, at least by inference, if not expressly, Section 7.1 has made clear that the powers of the Nigerian courts do not extend to setting aside arbitral awards that are delivered or that are seated elsewhere. And I think that Section 5(1)(e) or Article 5(1)(e) of the New York Convention that Abayomi referred to is adequate justification for that. And what we always need to juxtapose is that there's a difference between the right to set aside and the right to refuse to recognize and enforce. I'm clear in my mind. I'm of the opinion that the right to set aside is reserved for the courts of the seat. What the courts of other jurisdictions have the discretion or the power to do is the right to refuse to recognize the award, and that is clear. And if you take an analogy from court judgments, from the recognition of foreign judgments, obviously a court of a state that delivers a judgment feeling very confident that the judgment is proper and that it has jurisdiction to do so. But then the court of another jurisdiction that is asked to recognize takes its own view as to whether indeed that jurisdiction was properly exercised from an international perspective. So that's the analogy I like to draw between the right to set aside as against the right to enforce. So that aside, going to what I've been asked to speak to, and knowing very well that my time is limited, I'll be very quick. Revised set-aside provisions. Well, what I've said already actually sort of segues into this, because what the new AMA has done is to eliminate one of the greatest challenges, in my view, that led to delays under the old legislation. And this was the unclear and false dichotomy that existed between the section of the Act that dealt with domestic arbitration and the section of the Act that dealt with international arbitration. And the fact that both of these sections had provisions dealing with setting aside, or what the ACA described as the course against the award, and also had provisions dealing with refusal to recognize. And the provisions were not similar, they were not the same. So you had arguments in the case law as to whether the grounds on which you could refuse enforcement of an international award were the same as the grounds under which you could refuse enforcement of a domestic award, or the grounds upon which you could set aside a domestic award, and which gave rise to the argument in Sahelian, the fact that there was actually a provision in Section 48, which is in the portion of the Act that dealt with international arbitration, and that purported to give the right to set aside. Now, all that confusion has been taken away by the AMA, and Section 55 sets out the grounds upon which an arbitral award can be set aside. It mirrors the provisions of the New York Convention, and it applies both domestic. It doesn't draw a distinction between domestic and international awards. So, as has been pointed out, it deals a death knell to all the problems we've had with misconduct of the arbitrator and the elaboration that our courts have taken from that to create every possible excuse to refuse to recognize or to set aside arbitral awards. There's a concern about the language that has been introduced in Section 55(5), which appears to give the court some element of discretion, because even though Section 55(3) sets out the grounds upon which an award may be set aside, Section 55(5) says that the court, if satisfied that these grounds have caused substantial injustice. It will be interesting to see how that will be interpreted by the courts. I am not certain that there was a need to introduce that, but it is there, and it is my hope that it doesn't create a leeway for our courts to start, looking for means of escaping from the straitjacket that Section 55(3) seeks to put them in. The provision in Section 55, I think it's 55(4), has the public policy ground, but that is not new. That is in the New York Convention. It's in the UNCITRAL model law, and this is where I agree with Abayomi. I mean, if the court in Sahelian was refusing to recognize the award of the Swiss courts on the basis of public policy, then I think it should have been on very firm ground. But then it wasn't refusing to recognize, it was purporting to set aside, and that is where I depart from the decision. I think that it could have, if there was an application to enforce the award, it could very rightly have refused to enforce it on public policy grounds. Herman, if you could please move to the next slide. Now, the other changes, interesting changes that have been put in place and addressing specific problems is the provisions in relation to limitation. Section 34 has dealt with the problem created by the City Engineering Nigeria Limited and Federal Housing Authority line of cases, and now makes clear that the time for enforcing an award, that's to run from the date of the award. As you may be aware, the City Engineering case held that the Supreme Court and the courts below held that the time started to run from the date of the original course of action, which, given the length of time it takes to complete arbitrations and to go through the various levels of, to complete arbitrations, could result, as happened in the City Engineering case, in your right to enforce having been time barred even before your award was delivered if time continued to run. Now, section 57 and 58, again, this is a fantastic innovation in my view, because by and large, 57 and 58 mirror section 55. So it is the same grounds upon which, unlike the confusion which I identified that existed under the old law, it is the same ground upon which you can seek to set aside, that you can refuse recognition and enforcement. Section 58.3 contains an interesting provision which grants the court the power to stay proceedings for enforcement where a foreign seated arbitration is being challenged at the seat. And indeed, this again reinforces my view that by inference, if one reads this legislation carefully, it by inference supports the view that it is only the court of the seat that has the right to set aside. Because section 58.3 says, even where you're seeking recognition and enforcement, if set aside proceedings are ongoing at the seat, then the court ought to consider staying proceedings until those set aside proceedings are concluded. I'm running out of time, so I'll move on very quickly. Now, arbitration proceedings rules. Now, this for me is probably the most brilliant aspect of this act. Mr. Fagbonlu has already made some reference to it in his opening comments. But the fact, and this is something we've been agitating for a long time, the fact that you now have specific timelines within which the courts are mandated to deal with arbitration-related matters is a fantastic development. I think the next challenge for us as an arbitral community is constructive engagement with our judiciary to ensure that these laudable provisions are not frustrated by the mode of their implementation. They are clear, as Mrs. Ali also said, there's no reason why, if we can have election petitions being fast-tracked and concluded within 180 days, if we have fast-track proceedings for criminal matters at all levels of court, there's no reason why arbitral proceedings should not also benefit from the provisions of these rules, which specifically provide timelines within which arbitration-related matters must be dealt with. There are many of them, and the timelines are specified. After you have 21 days within which to enter appearance. Now, this I have a bit of a problem with. In I think it's Article 8, or I don't know if it's article or order of the rules. It deals with case management, and in 3A it says that you have 21 days after the date the defendant was required to enter appearance, or where a defendant is not required to enter appearance within 21 days, after the service of the originating notice of motion. I'm not clear why, again, an option has been given as to whether you need to enter appearance or not. I would have thought that from the moment the originating motion is served, the rules should have been clear that you have 21 days. It has given some scope for interpretive problems there. But by and large, generally speaking, I think that this arbitration rules are a fantastic addition to our jurisprudence. Now, one challenge that I see, which the rules seek to address in Rule 17, it says the rules of procedure in civil matters for the time being in force in the High Courts, Court of Appeal, and the Supreme Court shall apply to arbitration claims and arbitration appeals only in respect of such matters and to such extent as provision has not been expressly made in these rules. So it would appear that these rules are seeking to impliedly repeal the existing rules in our various courts dealing with arbitral matters. I have a concern as to whether that implied repeal is going to be efficacious. It might be efficacious in the federal courts, the federal high courts, the NIC, and maybe in the appellate courts. But taking a cue from the decision in Fashakin versus Schossmeier, I query whether it would be efficacious in state high courts where their rules are, where the legislative authority to make rules for those courts is vested only in the state legislature under our constitutional framework. But this is something that we would have to deal with going forward. And it is something which, again, as I said, if we carry the judiciary along, there's absolutely no reason why our state courts, the chief judges of the various courts, can't bring their rules in line with these provisions or expressly adopt these provisions because of the advancements that they make in arbitral practice. So very quickly, I'll touch on the last slide and I'll rush through this. This is the Award Review Tribunal. I see that it has generated quite a lot of interest. Mr. Fagbonlu has already spoken to it. And the answer to the questions, why should anyone opt in? I think Mr. Fagbonlu has addressed the fact that it's not entirely strange. But I think the question as to why should anyone opt in is a valid one. Obviously, Isaiah Bozimo, who's I think a speaker at the next session, would elaborate on this, because I read the very, very useful blog or article that his firm published just a couple of days ago. Obviously, this is not something that you put in every arbitral agreement. It has to be horses for causes. So if you're drawing up an arbitration agreement in relation to a lease of a property in Surulere, query whether you need to incur the additional cost of an arbitral award review tribunal when the decision of the award review tribunal can also, albeit on limited grounds, still be challenged in court. But if you have a business transaction of significant magnitude and where it is important that the decision, the parties are keen to ensure that the decision is as close to absolutely correct as possible, then definitely there's scope for opting in to use the award review tribunal. And in the expectation that the party that has opted in and the counterparty will be people who are sufficiently sophisticated and understand the benefits of arbitration. There won't be guerrilla warriors who are looking for every excuse to get back into court as quickly as possible. And as we say in this part, we want to use arbitration as just a pre-litigation process. So I think that there's merit in it. Obviously, it comes with some additional cost, but as I said, horses for causes, if the transaction or the agreement in which you are inserting an opt-in provision is of sufficient magnitude, that cost becomes negligible in the broader scheme of things. Now, in section 56.8, just to address this last point, it says that the award review tribunal would, I'm not sure now if it's the award review tribunal or the court, would only set aside if it finds that the decision is unsupportable, or that the decision of the it's the court, that if it finds that the decision of the award review tribunal is unsupportable, and there's a concern as to how do you interpret unsupportable in the context. But again, you can't have perfect legislation. If you had perfect legislation, lawyers would have no work to do. We will definitely be participating in the interpretation of these provisions going forward and in mitigating them. But I have absolutely no doubt in my mind that this legislation has moved us forward several light years from where we are. And I say kudos once again to those who pushed for its enactment. Thank you very much.
Thank you, Dr. Ajibade. Unfortunately, Abayomi had to leave us. He's speaking at the Africa Arbitration Academy here in London, so he won't be here for the questions. But we do have a few questions, Doc. I'm going to pick a few of them now for you to answer. I think one of them is from Pontian Okoli. He says he missed the question concerning the jurisdictional scope of the new act. Abayomi did say that he's of the view that international arbitration is incidental to trade and commerce in the exclusive list, and that as a result, the act covers interstate arbitrations, while the state legislations covered intrastate legislation. This person wants to know if there's a consensus from this panel on that. So what do you think, Doc?
I think the act has gone some way to trying to nail down the issues. I don't think it is totally devoid of controversy, especially the third, I think it's the third leg of Section 7 that talks about commercial arbitration, I think, in Nigeria. So it tries to segment, it tries to segment international arbitration, interstate arbitration, and then it talks about arbitration in Nigeria. Now, whilst you could argue that, international arbitration clearly falls within federal legislative competence, and you could argue that interstate arbitration arguably clearly falls within federal legislative competence, when you now have a third pot that talks about commercial arbitration in Nigeria, I'm not quite sure where to place that. So I think there might still, and I think that was Abayomi's conclusion as well, that the argument as to who has legislative authority in relation to arbitration is not over yet.
Yeah, I share the same view. I think the act did not completely resolve the question, but I think it does try to shed more light on what direction we're looking at, but it's left to see how the courts interpret it. Doc, I think there's one more question for you. I think Adeyemi Akisoya is asking, would it have been more effective if the arts decision was absolutely final, so that we should have rules and procedures that allow it to address those matters that could be ground for judicial review? So basically he's asking if finality of the arts decision would have been a much better outcome. What do you think?
Absolutely, I have no doubt in my mind. If that was within our gift, I think that would have been the common sense thing, because why go through the cost of an arbitration, go through the cost of an award review, and like I said, then you still have the window. No matter how narrow the grounds, the fact still remains that there's still a window to go to the High Court, and then from there to the Court of Appeal, and from there to the Supreme Court on the issues that the award review tribunal can deal with. But unfortunately, I without speaking for the drafters, I know that the Constitution, the right of appeal, is a constitutional right. So it's not, I wish we could, and we are struggling to amend that constitutional right to make it narrower. Indeed, the Nigerian Bar Association, in its proposals for amendment in the last constitution amendment exercise, made specific provisions in relation to arbitration. I believe our proposal was that arbitration should stop at the Court of Appeal and not go any further. If I had my way, obviously for a party that has opted into the ART, I agree with Mr. Akisoya that it probably should just end there, but that would require significant constitutional amendment.
I mean, I totally agree as well. I think the next question is for me. It's Max who talks about Sakamori and LSWC, the 2022 Supreme Court decision. I mean, he says that the Supreme Court held that the filing of a statement of defense does not waive the party's right to apply for a stay. Unfortunately, I'm not very familiar with details of that decision, but even before Sakimori, there were decisions that held that if you filed, there were very few decisions that held that if you filed a statement of defense alongside the stay of proceedings application, you had not waived your right to request a stay. But if you file a statement of defense before requesting stay, I think it's very difficult conceptually and theoretically for you to argue that you still have a right to, of course, to request a referral to arbitration, unless, of course, the claimant agrees with you. I think the key thing with all decisions that existed before the Act is that if they're not in consonance with Section 91, subsection 10, which says you must interpret the Act in accordance with its international origins, the model law and all of that. If they're not in consonance with that, then there's a ground to revisit all those decisions afresh by saying, this is the law now, this is the law that has changed. So all those decisions, to the extent that you don't comply, they don't fulfill the interpretation requirements in Section 91, subsection 10, those decisions can be revisited and reviewed. The other thing I would say is, and we haven't mentioned this expressly, but the Nigerian Arbitration Act does something very interesting in relation to the fulfillment of the objectives under the New York Convention. When Nigeria acceded to the New York Convention, we put in place something called the reciprocity reservation, meaning that would only enforce awards from New York Convention states. But if you look at the letters of the Act actually makes it absolute. It says irrespective of the states where the award is rendered, would enforce. And the same for arbitration agreements as well, as absolute. Irrespective of where the arbitration agreement is drafted and whatnot, would enforce. So I think there's a new angle to all these provisions, notwithstanding what the case law says previously. Doc, do you have anything else to add to that?
No, I agree with you, but there's actually that reminds me of a point I wanted to address. I think there was a bullet point on the slide concerning limitation, which raises a similar point as to what would be the situation for arbitrations that were pending before the Act. Would the city engineering situation still apply? And I think that revolves around the age-old chestnut as to whether limitation laws are substantive law or procedural law. I lean, and I think the majority of academic opinion is that limitation laws are procedural. So you take that law as it is at the time the issue is raised. So it's not really a question of retrospective application. Anybody who raises the city engineering type of argument now, post 26th of May 2023, I don't think we'll have much chance of success.
I agree completely. I think there's one more question from, it says potential pitfalls of the new art regime. I think Doc, you answered this, but do you want to just talk about this a bit more? The pitfalls of the new regime, particularly the award review tribunal.
Well, yeah, I mean, I think I've mentioned it already. As you say, the award review tribunal is innovative. Before listening to to Mr. Fagbolu, I was only aware of the closest thing I was aware of to it was the ICSID annulment procedure. But I'm glad to hear that we're not totally, we're not reinventing the wheel, that it's available in the US. But even if we were the first to do it, as the saying goes, being the first to do something is not necessarily a bad thing. So I think it's a great innovation, and I think it is designed to address a specific challenge in our system. I think Mr. Kisoya's question actually it establishes what the drawback is. The drawback really is that it provides a remedy, but it's not a complete remedy for the problem that it seeks to solve.
All right, thank you so much, Doctor. We have to wrap up this session now. We have the best session saved for last. And I say this being a member of the second session, not being a member of that session. And we thank you for listening. Please don't forget that this is not an exhaustive review. There are lots of reviews going around, so please read up. And if you have any questions, please send messages to myself, Dr. Ajibade, or Dr. Kubote, and we would answer them. I will now invite to the next session and the final session, I have to call this the champagne session. We wanted to put this first, but we have to put this for last. We're saving the best for last. And Ms. Roberts is already smiling because you're about to have a blast. I have to invite Mrs. Fumi Roberts, my big brother, Isaiah Bozimo, and I mean, the rock role model of everyone in this room, quite literally, Professor Paul Idonije, Senior Advocate of Nigeria. Isaiah, you're going to anchor this session. I'm going to drop off now so they can see all the superstar faces. I have to say that we put together this panel because all three people were instrumental in the drafting and enactment of this groundbreaking legislation. Without further ado, I'm just going to, go away and leave it to this legend, so to speak. Isaiah, over to you.
Ife, thank you so much. I'm not quite sure I fit into the legend category yet, but I'll take it. And thank you for classifying this as the champagne session. It was intended to be the curtain raiser, but we'll certainly do our best to make it a fitting end to this very, very brilliant discussions. I have enjoyed each of the interventions so far. And wish I could have jumped in at some stages to give my views, but the conversation is ongoing, and I certainly look forward to other opportunities where we can continue this conversation, because the what next element of the enactment is really, really critical. Well, so to this session, Dr. Ajibade in his intervention mentioned that it's been a 10-year journey. Doc, it's actually been an 18-year journey, and that 18 years hasn't been quite straightforward. In fact, it's been full of twists, turns, almost like a box office movie, but instead of a movie where ultimately the hero triumphs, this is the 18-year saga that culminated in a significant stride in Nigerian arbitration with the enactment of the Arbitration and Mediation Act. And as you've heard from the previous sessions, this act has a number of groundbreaking features, which represents a significant chapter in our ongoing narrative towards a more competitive seat and a more efficient, fairer dispute resolution process. So to guide us through how we navigated this epic saga, which I'm equating to a movie, we have two exceptional lead actors who have been instrumental in shaping this plot, this thrilling narrative. And first, we have a legal colossus, as Ifemena has described, Professor Paul Idonije, a distinguished professor of law and a senior advocate of Nigeria. And much like a determined protagonist, Prof has persevered against all odds and has been deeply involved in this reform process. And he has fought tirelessly through the National Assembly and through other fora to ensure that we have this positive change. And also we have Mrs. Fumi Roberts, and if this were a movie, Mrs. Roberts would be akin to the visionary director. She's an accomplished legal practitioner who has meticulously guided the work of the ACA Reform Committee and has steered us towards the final enactment of the Act. So together, this ensemble will guide us through the 18-year plot. And without further ado, we will begin with Act 1, Scene 1, which Professor Idonije will take us through. So, Prof, over to you, sir.
Isaiah, thank you very much. Let me thank LASIAC for this opportunity. I'm sorry that what was meant to be the first session is the last. I was just cracking a joke with a friend a couple of minutes ago. The American Bar Association had their webinar today where I spoke, and I said to a friend that I was leaving New York for Lagos, that my PJ was waiting for me. He was trying to call me. I said, no. My PJ was waiting for me as I was leaving New York for Lagos to get to Lagos before 6. Here I am. I listened to the last session, and I was really, really fascinated by the contributions. I will try in the course of my brief contributions to clear some of the issues and also raise some issues. Now, let's start from the beginning. In 1914, when we had the amalgamation, we had the Arbitration Ordinance of 1889. Arbitration Act of the UK of 1889, which became the Arbitration Ordinance, which later became Cap 13, Laws of the Federation of Nigeria 1958 for Lagos only, and the regions, Western, Eastern, and Northern, had their own arbitration laws. Now, this situation persisted through independence till the Republic. But on 17th March 1970, Nigeria acceded to the New York Convention. You recall that the convention was a convention of 1958, when Nigeria was a colony, and therefore we could neither sign or ratify the convention. So it was in March 1970 that Nigeria acceded to it. In 1985, the UNCITRAL adopted the modern law. And of course, we all know that the modern law was meant to unify international commercial arbitration. Now, during the military regime, we had the arbitration and conciliation decree. It was decree number 11 of 14th March 1988. What this decree did was to pick from the old Arbitration Act and the New York Convention. So the decree provided for both domestic and international arbitration. Now, so people ask me, what is different between that decree and Cap 19, LFN 1919, and Cap A18, LFN 2004? There's no difference. It is the same law, it's just that we are changing the caps. Now, what was introduced by that decree? That decree gave us a uniform act. Don't forget, it was a military regime at a time where the decrees were superior to even the Constitution. So we had a uniform act for the Federation. And it did. If you look at Section 58 of that decree, it provides that it should apply throughout the Federation. Now, for the first time, we provided for international commercial arbitration that was inspired by the UNCITRAL modern law of 1958. Lastly, that decree provided for conciliation. But by 29th May 1999, we now had a constitutional government. That gave us a challenge because the decree, as a decree in May 1919, was an existing law, if you look at Section 315 of the Constitution. But the challenge was, who had the powers to modify it? The National Assembly or the State Assembly? So that was an issue that posed a challenge. Just now, I listened to the argument of my friend, Dr. Ajibade SAN, about this and the issues raised by Abayomi Okobote. Now, when we went through the exclusive list and the concurrent list, we found that there were no words like arbitration and conciliation. But we found that in item 62 of the exclusive list, there's provision for trade and commerce between Nigeria and trade and commerce between states. We also find an item 68 that provides for any matter incidental or supplementary to any other matter mentioned elsewhere in the list. I would say yes. Arbitration and conciliation, being means of resolving disputes arising from trade and commerce, are incidental and supplementary to item 62. So when on the 23rd of September 2005, the then Honorable Attorney General of the Federation, Chief Bayo Ojo SAN, who himself is a notable and chartered arbitrator, set up the Orojo Committee. The committee was made up of 15 members, and it was meant to reform and harmonize arbitration laws in Nigeria. Now, what was our mandate? It was very clear. To review Nigeria laws on arbitration and other ADR mechanism with a view to proposing necessary reforms and to bring the laws in line with modern trends. That was our main mandate. Let me remark here that the secretary of that committee was Tunde Fagboholo, SAN. The first draft, now, on the whole, we have had 4 drafts. The first draft of 2006 was a draft of Tunde Fagboholo. I think that Tunde must be given that recognition that he did the first draft. And as you will find, after the first draft of 2006, we had a draft of 2017, we had a draft in 2019, we had a draft of 2023. If you look at the subsequent drafts, you will find that they were just minor additions to what Tunde drafted in 2006. Now, what was the procedure adopted by the Orojo Committee? We said that we asked for submissions. We called for memorandum to be submitted. We had plenary sessions. At the end of the day, we had a national workshop. Now, as my friend Tunde Ajibade was submitting, we resolved that instead of having, if you look at the ACA, the ACA is in 4 parts. Part A, that you find in sections 1 to 36, they deal with arbitration. 37 to 42, they deal with conciliation. 43 to 55 deal with international, additional provisions in respect of international commercial arbitration. And the last part, miscellaneous matters. We resolved that we are not going to have a law dealing with domestic and international arbitration. We are going to have one law dealing with arbitration. And what was our approach? Our approach was basically 3. That there are provisions in the ACA that we will retain. There are provisions in the ACA that we will modify. Then we will introduce new provisions. If you look at the ACA and the AMA, if I may call it AMA, you'll find that section 2, again, when I refer to these sections, they were sections that were retained in 2006, 2007. Subsequently, some of them may have been amended, but in 2006, section 2 remained the same. Section 2 deal with the fact that arbitration agreement is irrevocable except because of the parties or the court. The issue of death of the parties, section 3, section 11 deal with appointments. So we retained some sections which I don't think I have time to go through, but I want to go through the modifications we introduced. Now, like I said, 3 approaches: retain subsections, modify some sections, and introduce new sections. Section 1 of ACA was a problem in terms of agreement being in writing. It was a problem. And if you look at the Australia Modern Law of 2006, you find that Section 7 has expanded the definition of arbitration agreement. At that time, too, we had the Australia Modern Law on e-commerce. So we took advantage of these 2 instruments to expand the definition of an arbitration agreement. I had conversation going on just now about stay of proceedings. I find sections 4 and 5 of the ACA very interesting. Like what I rightly observed, section 4 came from the 1958 New York Convention. Section 5 came from the old law. And, when I heard words like cutting and pasting not properly done, I am sure that what we have done now may be described subsequently as cutting and pasting not properly done. Now, what did we do with sections 4 and 5? Section 4, you recall that by March 1970, we had acceded to the New York Convention. If you look at Article 2, sub 3 of the New York Convention, it provides for sale of proceedings. But we took that provision halfway. We didn't add words like, unless the court finds the agreement null and void, inoperative, and incapable of being performed. So we said we will merge sections 4 and 5. And, you know, in England, the English Act of 1975 made provisions for domestic and international arbitration. And clearly in that law, they provided for a stay of proceedings in respect of domestic arbitration and stay of proceedings in respect of international arbitration. But in Nigeria, we use section 4 and 5 without explaining clearly that one was meant for domestic and the other was meant for international. Section 6, the number of arbitrators, this was mentioned just now. We now say that instead of, you know, the problem that section has always given to me, you have a small dispute, then you are forced to, we believe in the principle of party autonomy, but you'll be forced to appoint 3 arbitrators for a very small dispute. So we felt, so no, let it be 1 unless the parties otherwise determine. Section 7.4 deals with appointment of arbitrators. And we said in ACA provides that when the court appoints, that decision is final. That created problems, and we said that should go. Now, like, really, if I repeat what I've said before, it's partly because I was not here, but the ones I was here, I heard, I will refer to them. Now, if you look at section 7 of the ACA and section 44 of the ACA, they deal with appointment of arbitrators. If you look at sections 8 and 9 of the ACA and section 45 of the ACA, they deal with the challenge procedure. We decided to merge them. Section 30, sub 2, which dealt with misconduct, we said that should go. Now, section 13 of the ACA that deals with interim award, we found that the Australian modern law of 2006 had more expansive provisions. We decided to adopt that. Section 14 of the ACA that deals with the right of persons to be treated fairly, equally, and be given opportunity to present their cases. We didn't quite capture what operates in other jurisdiction. We added that the tribunal must do everything to avoid unnecessary delay and expense. Section 15 of the ACA, you find that 15 deals with domestic arbitration, 53 deals with international arbitration. We said, no, we cannot have 2 sections. So we merged 15 and 16. Section 26 that deals with the content of an award. That is where we introduce the fact that the arbitral tribunal has a lien on the award, and that the duty to pay our fees is joint and several. Section 29 and 30, and you see, you find 29 and 30 dealing with domestic arbitration, 48 dealing with international commercial arbitration. We said, no, we cannot have the 2, we merge them. Now, I also find sections 49 and 50 very interesting. Why am I saying this? 49 deals with cost of arbitration, and it's in part 3. So if you are conducting a domestic arbitration, can you go to section 49 and use that as cost? Or like part 3, that section 43 provides that in addition to other provisions of the Act, in other words, part 3 to be read with other provisions, but we don't have a similar provisions in part 1 dealing with domestics. So you find that you are applying section 49 for cost of arbitration when part 1 does not expressly provide for that. So we now had 49 and 50 just dealing with arbitration, like was argued earlier. 31 and 51, this was setting aside 31 domestic, 52 international, 32 domestic for refusal to enforce an award, and 53 for international for refusal to enforce an award. And I also find 32 very interesting. It provides for refusal, but there are no grounds. 52 provides for refusal, there are grounds. There are now court of appeal decisions that provides that we cannot borrow from section 52 and apply them to section 32. So with this act, that has been done with. So we now have a new act that has just two parts. One part for arbitration, one part originally for conciliation at that time, then another part that was miscellaneous. Then the last thing we did was the introduction of new provisions, immunity of arbitrators. This was a nightmare of arbitration in Nigeria. If you remember the old case of Saltcliffe and Tagra, RSC and RSC. So as an arbitrator, we are relying on the common law position on the issue of immunity, but it's expressly in the act now. Set of limitation, I like the position taken by my friend Ajibade SAN. Yes, that Federal State Engineering, Federal House Authority of State Engineering was a nightmare for arbitrators. And I was very interested in saying that that section that decision is reversed by the act. Consultation and concurrent hearing were introduced by us. Payment of interest, remedies. You know, in arbitration, the issue has always arisen as to whether, for instance, can we rectify an agreement? Can we order specific performance? Can we grant injunctions? Because the old SCA didn't provide for them, but in the new act, we did. Security for cost was not in the old act, we did. Like I said, we provided for several and joint liability. Learn on the award. I love this. I love it in the sense that sometimes you give an award and you are not paid. So we now said, then lastly, the arbitration procedure rules. I like the analysis given by Ajibade SA on this. For me, it was a novel provision. If you look at the various high court rules, some provide for procedure for enforcing, you know, look at the ACA. There are references to court, without indicating whether how to initiate the process. Is it by motion ex parte, motion on notice, review? So we decided that we should have these rules to apply in states where the Federal High Court rules did not provide for how to enforce the award. Now, we added more provisions on conciliation because by 2002, OSITRAL had a model law on conciliation. So unlike the 1988 that merely used the OSITRAL arbitration rule of 1976, in 2006, when we were drafting, OSITRAL had a model law on conciliation, 2002, that we use. We applied the same approach to conciliation, i.e., what are the sections to be retained? 2, what are those to be reformed? 3, what are those to be introduced? Now, after taking all these positions, we decided to draft 2 laws. I'm aware that we are all aware that we drafted 2 laws. And I'd like to take the issues raised about the jurisdiction of the federal law. When we drafted it, we said for state, Nigeria and dispute between Nigeria and other states cannot have jurisdiction. Interstate disputes, states cannot have jurisdiction. Again, you know that is the National Assembly that makes laws for the FCT. What is missing in the present act? We have tried to ensure that we have an act that is flawless, but I find that it's impossible. One of the drafts I have shows clearly that this federal act applies to the FCT and international arbitration. No, 3. FCT, dispute between states, international arbitration. But I don't know, somewhere along the line, they drop out that provision. So what you have there is commercial. I know that it will create problems, but that was not our intention. Our intention was what we drafted for the federal government, we apply to FCT, dispute between states and international disputes. Now, for what we drafted for the states, we drafted 2 bills for the states. Now, the one for the states, that's what Lagos State modified and passed their law in 2009. Rivers State, 2019. Delta, I'm proud to announce that Azaya single-handedly drafted the Delta State Arbitration Law 2002. But what is what is interesting to me at the moment, what I was going through, before now, I used to argue that it's the only Lagos State that has a model law on arbitration in this country. I just found that in regards to grounds for setting aside, Lagos State still has misconduct. And Rivers State still has misconduct. It's only data that does not provide for misconduct. So with the enactment of the AMA 2003, Lagos needs to look at its act again. I think that provision on misconduct should go out of it. So when we finish drafting, we send the two bills to Chibayo Ojo as the Attorney General of the Federation. By 2006, Constitutional amended its model law. And there were changes in the ICC rules, in LCIA rules. And Chibayo Ojo, as AG, sent the federal bill to the Federal Executive Council. It became an executive bill and got to the National Assembly in 2007. That bill remained there till 2016. And in 2016, the arbitration reform set up a 33-man panel to review that bill. That committee was chaired by my friend and younger sister.
Prof, I'm so sorry to interject, Prof. It appears your arm is interfering with the mic. We couldn't hear you properly.
Oh, where? At what point?
No, just now. But
okay, at what point? Where was I? Where was I then?
No, you just after the part you spoke about the fact that the laws were before the House for that amount of years. But it's also to draw your attention to the fact that we also have to give Mrs. Roberts an opportunity to.
Yes, I'm just leading. I'm just getting close to her now.
Wonderful.
I'm saying that in 2016, the arbitration community set up an arbitration reform committee that was chaired by my friend and sister, Mrs. Fumi Roberts. And I chaired the technical committee that handled the drafting. Other members of the committee were Senilayo Ojo, fellow, and Isaiah Buzimo, who was our secretary. At this point, I will hand over to Mrs. Fumi Roberts. Thank you very much.
Thank you very much indeed, Prof, for that brilliant expose, which matched my description of the journey as a saga. I think you've painted the first half of that saga very well. So Ms. Roberts, over to you then. So you will pick up from Act 2, Scene 1, from the formation of the Reform Committee up to the enactment. And unfortunately, I'm mindful of the time, so I know you are a very, very skilled time manager. And I know you will do justice in the time remaining in the session. So over to you, ma'am.
Thank you very much, Isaac. Can you hear me? Can you hear me?
Yes, Isaac, we hear. Please go ahead.
Yes. Okay, thank you very much. And thank you to LASIAC for this invitation. And I say that thank you, and I mean it very seriously, because it's important for people to know the journey, because of some of the comments that have been made when the AMA came into being. And I always say that sometimes the process you take to arrive at a decision may be even more important than the decision itself. We heard what Prof said about comments being made about court and pace and so, and this underscores the importance of this session at this webinar. The Reform Committee was established when members of the arbitral community came together to look at some of the bills that were before the National Assembly, bills that didn't add any value to what we were talking about when it comes to reform of the arbitration sector in Nigeria. And a meeting was held at City Hall. I can't remember the date, but that was sometime in 2016. And that meeting was championed by the Chartered Institute of Arbitrators Nigeria branch. And as Prof said, the reform committee was set up, the technical committee chaired by Professor Paul Idonije, working with Isaiah Bozimo, Sheila Oju, and I. And one of the very first things I did personally was to engage with Chief Bayoju and ask him, why was it difficult for the National Assembly to pass that bill that was before it? And I'll be eternally grateful to Chief Bayoju for the insights he gave me. We spent almost an hour on the phone. And one of the first lessons that I learned is don't make this an executive bill. Because there's so many reasons that he gave during that lengthy conversation. And another outcome of my conversation with him is the fact that there's a need to involve as many arbitral institutions as possible. And I'm glad that you took that decision. It was very challenging, reining in some of the institutions. Some didn't believe in our work. Some were of the opinion that, oh, this is, well, many ego personality issues came into being, but we were tenacious and determined that all of us must be involved. This is of national importance, and it had nothing to do with an individual. And I'm glad that we're able to do this because it was eventually a lifesaver. And I'd like to remind Prof of an incident that happened even before the bill was passed by the National Assembly. It was at a meeting when a senior colleague got up and said that, oh, that bill, well, a few people just sat down and drafted the bill. There was no consultations and so on. And Prof was able to answer and say that, no, but your organization had representation on that committee and mentioned the name of his representative on the committee. So it was a bill that was put together by the entire arbitral community in Nigeria. It wasn't something that a few people sat down and did some cutting and pasting. The role played by some, of course, when you have a large committee made up of almost 40 members, some people will play more prominent roles than others. But then Prof has done a wonderful job of articulating some of the things that were in the bill. And every draft that came up, what we did was to circulate it to members of the committee. And all our meetings were online. The only time we held a physical meeting was at the retreats, which I'll get to in a minute. And what the representatives of each of those arbitral institutions were supposed to do was to take the bill to their respective members and gather their comments and send to the technical subcommittee. While some did not. And let me give kudos to the Nigerian Chartered Institute of Arbitrators, because what they did was to set up a 14-man committee made up of eminent practitioners who came up with a well-articulated report, which was carefully looked at by the technical subcommittee. And some of the comments were brought to bear in the bill that was eventually sent to the National Assembly. And like I said, we held only one physical meeting, and that was at a retreat held on the 21st of October, 2016, graciously hosted by my very good friend, Mrs. Joy Rhodes Bible, SAN, in her office. And present at that retreat were industry players, Mrs. Adekoya, SAN, Professor Tunde Fagbonwolu, SAN, Mr. Dede Belgore, and so many others. It was a 2-day retreat, and there were times I thought that people were going to come to blows when we had those robust debates. It was the first time Mr. Tunde Fagbonwolu presented the award review tribunal, and there were strong oppositions to that ART, and while some supported, I mean, it was really very interesting. And I've attended many retreats in my life, and I'll say that that was one of the most significant that I ever attended. Eventually, the bill went to the National Assembly. And at the ICC conference, I made a statement that if anyone needs a consultant on what it takes to pass a bill in Nigeria, please consult me. And I can even do it free of charge. It was an ennobling experience indeed. And I must give credit to the NBA president. Even before he became the NBA president, Mr. Yakubu Mekio, SAN. He took it on personally, used his social capital, used his network at the National Assembly to get it sailed through. And that bill was sponsored by Senator Andy Uba. Many people didn't know this. Because of the advice of Chief Bayo Ojo not to make it an executive bill, Senator Andy Uba just picked it up and ran with it at the Senate. And it was passed by the Senate and went to the House of Representatives. And then there was a ton of events. On the 7th of August 2018, the Singapore Convention opened up for signature. And Nigeria was one of the first countries to sign that convention the very day it opened up. So we then held a meeting. Is there any point at this time having conciliation provisions when even UNCITRAL has recognized the fact that conciliation is hardly ever used and mediation has now come to the fore? UNCITRAL has come up with a model mediation law. We now have this Singapore Convention, which has already been endorsed by Nigeria. So we took the decision to withdraw the bill from the National Assembly. We replaced conciliation by mediation, predicated on the UNCITRAL model law on mediation, and we returned it to the House of Representatives. The House of Representatives passed that bill and it was sent to the Senate, and the current chairman of the Nigerian branch of the Chartered Institute of Arbitrators, Chief Bola Akinola, had to press some buttons, got in touch with Senator Shola Bamidele, who championed it, and the Senate eventually passed the bill. And it was sent to the president for his assent. And then another scenario emerged. And so many months down the line, objections came from the Federal Ministry of Justice. It was a two-page document stating the various objections, but the most significant was the objection that we tried to ratify the Singapore Convention in the new bill. But what we tried to do was exactly what the New York Convention, what the ACA did for the New York Convention. And if you look at the ways by which the Singapore Convention could be ratified, what we did was actually one of the various methodologies proposed for the ratification of the Singapore Convention. But the Federal Ministry of Justice said no. Several meetings were held, and I think sometime in November, I went to see this Solicitor General of the Federation, and Mrs. Beatrice Jedi Agba. And believe me, she's one remarkable lady. At that meeting, she called all the different heads of departments. We held a meeting, and she gave an assurance that Mrs. Roberts, go and work with my team. Directed the Director of Legal Drafting to work with us and come up with a document that they can approve of. And she assured us that we shouldn't worry. She's going to put steps in motion to ensure that the Singapore Convention was ratified. So we caved in, removed the Singapore Convention from the AMA, and it was sent back to the presidency from the Federal Ministry of Justice. And I must thank the director of the office. I can't remember her name right now. She supported us, did a lot to work with us, together with the young man she attached to work with us throughout the election period. We were working on this. And let me also seize this opportunity to thank Professor Wale Olawoyin, SCN, who up till 2 a.m., 3 a.m. was up with us trying to look at the nitty-gritty details that needed to be dealt with, the typos in the bill before it went back to the presidency. The presidency sent it back to the National Assembly for revalidation, and Mr. Mekio stepped in again, and then it went back to the presidency the last week of the lifespan of the last executive. It was a nail-biting experience. I was out of the country. Prof and I will get on the phone, we'll talk about it. I'll call the Solicitor General And she kept telling me, Mrs. Roberts, the president will assent to this bill. I returned to the country on a Thursday, on a Wednesday, the last Wednesday of the life of that executive, and it hadn't been signed onto. And on Thursday, it hadn't until Friday, the very last day, when it was signed by the president. In a nutshell, that's like encapsulating the work that had taken almost 10 years to get to where it is today. And a critical question I'm sure many people would ask is, what then is the fate of the Singapore Convention? Mrs. Beatrice Jedi-Egba is a woman who keeps her word. Shortly after our meeting with her, she told us what she wanted from the private sector, which is to get a letter written by the Regional Center for International Commercial Arbitration, Lagos. That letter was eventually written and sent to her, and a memo was sent to the Federal Executive Council. And I think at the second to the last session of the Federal Executive Council, the Federal Executive Council gave the green lights for the ratification of the Singapore Convention. So what we're waiting for now is the extract, which we hope the current president will sign, and then the instruments will be lodged at the UN offices in New York. So that's a summary of what we've done in the last 10 years. So over to you and Ezekiel. Sorry, Isaiah. I just finished a meeting with an Ezekiel. That's why it's still in my brain. Isaiah, thank you.
I don't mind being on Ezekiel for this purpose. Thank you so very much for your skillful exposition. And thank you also to Professor Edonige. I see there are some questions in the Q&A. They're not necessarily tied to this panel. So I'll just inquire from Efemena if we have time to still address these questions, or otherwise I'll say thanks on behalf of this panel and hand it back over to you.
Hi, Zai. It's perfectly fine for our experts to address these questions if they want to. I coincidentally just sent an answer to Max, but I mean, it's okay if the panelists want to have a go at it.
All right, very well. So, Prof. Mr. Roberts, there was a question from Max. Maybe I'll still read it out just in case you would like to give it a shot. It says, in the agreement embodying the arbitration clause, Party A's address is in Lagos, Party B's address is Asaba. The contract is for delivery of goods or a service in Abuja. The arbitration clause simply says all disputes shall be referred to binding arbitration without specifying any law, presumably any arbitration law. Which law would apply, or would this be an unenforceable pathological clause? So, Prof, do you want to take a shot at that?
Yeah, I'll just straightforward describe it as a pathological clause. I think that this is a lesson that many of us as lawyers must learn to draft enforceable arbitration agreements. Now, there are model clauses. We do not need to reinvent the wheel. So if you are new to this business, simply adopt an available clause. But if you must draft, get an expert to assist you in drafting. So simply put, I would treat it as a clause that is sick, that needs treatment. What I do in practice for such clauses is to ask the parties to prepare a submission agreement in place of the earlier agreement. So with a properly drafted submission agreement, then an arbitral tribunal can have jurisdiction. Because with that type of clause, there may be challenges in enforcing it. So we advise the parties to draft a submission agreement. Thank you.
Many thanks indeed, Prof. Maybe to offer an alternative position, even though I don't disagree with you, perhaps it could be treated as an interstate arbitration, given the different bases that are in play here, and maybe the AMA would apply. Just to give a plug to the Delta State law, if the law of the contract was actually Delta State, then it would be saved. It wouldn't be pathological, and it would fall under the Delta State law, and a submission agreement would also solve it. But like I say, this is an ongoing, revolving conversation, and I'm sure we will have many more conversations just like this one. So what
the respondent in such a matter would probably agree with Prof and say it's pathological because he doesn't want to go for arbitration in the first instance anyway.
Yes, indeed. So thank you so very much, Prof and Mrs. Roberts, for doing justice to what Efemena described as the champagne session. Regrettably, we didn't have any glasses to clink, but I congratulate you for your role and indeed.
No, Isaiah, we should not stop at that level. I said Tunde Fagbolu SAN drafted the first bill in 2006. Isaiah, you drafted the 2017 bill. Isaiah, you drafted the 2019 bill.
2019 bill.
Even when you were Attorney General of Delta State, you were still involved in the drafting of the 2023 bill. I think that, Isaiah, we owe you a lot. I was just mere chairman. Isaiah was the one doing the redrafting. I must say that it's not possible for us to acknowledge all those who played roles in this bill. But in terms of drafting, is Tunde Fagbolu and Isaiah Bozimo. Thank you very much.
And I see that Professor Tunde Fagbolu wants to say something. And I think he should be given the opportunity to say whatever he wants to say. And particular thanks should also go to Boshashore, SAN, and Mr. Okubote, Dr. Okubote, for making pains to ensure that the third-party funding provisions are incorporated in that law.
And before today speaks, if anybody needs the 4 drafts, I need them. I'm a commercial lawyer, and so we will discuss terms. I charge in forex, in hours, or part thereof. Thank you very much.
And I'm Prof partner in that venture.
No.
Yes,
it was my technological incompetence that was showing me up, because
I see.
When Prof was praising Isaiah, I wanted to engage the applause emoji.
Oh, okay.
I ended up engaging the raised hands one. So congratulations, Isaiah. Well done.
Well, I think it's more appropriate to say congratulations to all of us, because we each played a very significant role at different stages. So on behalf of these panelists, the brilliant Professor Edonige and Mrs. Roberts, I say thank you very much, LASIAC, for the invitation. Thank you very much to the audience for staying with us and listening throughout. And I will hand over back to my brother, Ife.
Thank you so much, Isaiah. Thank you, Prof. Thank you, Mrs. Robert. Was, of course, the champagne session did not fail to deliver. I sit here excited, having studied all the developments and seeing it come to light and seeing it discussed even in this session. I am super excited for what's coming next, and we all look forward to how the act is implemented. Without further ado, to wrap up the webinar, I call on Mrs. Rattray, Deputy Chairman of LASIAC, to give the closing remarks. Hi, Mrs. Rattray.
Hi, Efemena. Thank you very much to everyone who has attended today, and particular those who have helped all of us. It's not only participants in Nigeria who are engaging with this exciting development of the new act. I mean, there is intense interest across Africa for sure to see how this act will unfold, and the development of the jurisprudence in Nigeria, and the innovations as everywhere in the world reform processes in arbitration and ADR in general are happening. We started this webinar talking about Nigeria as a seat and raising the vision of Nigeria being a place where transactions within Africa, not necessarily involving Nigerian parties, would be arbitrated, would be resolved as Nigeria grows in recognition as a safe seat. And thank you very much to Mr. Tunde Fagbonu, SAN, and Mrs. Folashade Ali for presenting on those topics and moderated by Mr. Majmite. And then we went into looking at this, the surgical look, I believe, was the next session, looking at the changes. And thank you very much to Dr. Tunde Ajibade, SAN, and Dr. Abayomi Okuwote, and ably chaired by Efe. And really all of, I think everyone, especially, I'm sure there are majority lawyers on this webinar, really wanted to engage with all of the case, how cases might be argued now compared to in the past, looking at the changes that have been made. And so, of course, we look forward to further webinars digging deeper into the implications of the changes that have been made. And then we have had a wonderful closing session as Isaiah has described as, you know, the drama of the implementation of the, you know, a bill becoming an act and how that has unfolded. I think we have Mrs. Roberts and Professor Paul have been shared wonderful stories with us, which we would not have known. Those of us who were not involved would not have known all that have transpired over that 18-year drama. And I think the takeaway, that process is so important, the process that it took for us to reach here. And now here we are, we have the new AMA, and everywhere we look forward to seeing its implementation and all of the jurisprudence that will develop therefrom. And so I would like to thank all of you participants, speakers, moderators, as well as the general participants for being here on behalf of LASIAC. We look forward to future webinars and engaging with you, and have a very good evening, all of you, and we look forward to engaging with you again. Good evening.
Thank you, Mr. Ache. Thank you all for coming. I just got confirmation that we're going to have the recording on YouTube, and the presentations and speaker profiles will be sent via email. So thank you again for coming. Have a lovely evening. See you soon.